welcome to the Off Label Podcast. Usually a twice weekly dose of sanity in an insane world, but we're doing more. Today, and this one's gonna be quite easy. We're just gonna play along with needing ears for this because we're about to hear the Supreme Court arguments for banning TikTok. It looks like our president elect is now officially a convicted felon, and all that shit's just weird. I'm not. I'll take a look at it and we'll determine what's going on this weekend and probably talk about it a lot more. But let's just go ahead and hit this up real quick so we can get through the Supreme Court thing that is still going on at this point in time. This is probably going to be a long hearing. But we're going to start from the beginning. Ladies and gentlemen, let's go ahead and hit it.
Hey kid, don't ever let them get inside your head. They'll tell you what to do in life instead of everything you know that you could get. Don't let them guide your life towards regret. I'll fight for what I love with every breath. My past is filled with things I won't forget. I use them all to push me to my best. So treat the worst of times just like a test. If only I could go back in time, I'd tell myself that everything will end up alright. Just push yourself, test yourself, figure out what you like, and find your limits, don't be rigid, always work towards a prime. Surround yourself with open minds, people can change your life. A few friends with intent can help you feel alive. Find a passion, take some action, and with a little time, just be patient, make a statement, try to enjoy your life. They'll try to kick you while you're down. They wanna rise up while you drown. They wanna fill your head with doubt. They're silently scared that you'll figure it out. I'll make it look like I'm losing. Won't bother hiding my bruises. And when they finally think you're wounded, then it's your chance to be ruthless. I'll make it look like I'm losing. Won't bother hiding my bruises. And when they finally think you're wounded, then it's your chance to be ruthless.
Let's make something not Italian.
You know she can make it disappear. Truly a job when she can whisper in her own ear. Takes her 7 business days to brush her teeth. Smile free the movie, we found your new lead. Her voice echoes by itself until insurance denied. She eats salad with a pitchfork after dating black guys. She can taste tomorrow's dinner. She speaks for everyone. She speaks in IMAX. She can sing 2 songs at once. About Lord, she can sing in 3D. She can eat a banana horizontally. Why did she overline when her mouth was already half her face? A dentist dream, she can eat a cucumber sideways. Puts on lipstick with the paint roller, I can see the back of your head. She can deep throat a thermos, she sneezed and bit herself in the chair. Legend has it to 747 accidentally landed there. Tell which side to start kissing, I am not sharing food with her. Shut it! Shut it!
Gotta love them. Every time you gotta love it, ladies and gentlemen. Today, just gonna be some easy listening. We ain't gonna get into anything here. But we do have the Supreme Court hearing about TikTok. We're gonna get into that. And hear what's going on within our own Supreme Court. This seems to be just kind of like a fuck up all the way around now. I don't know where they're going with it. I don't know how this is playing out, but we're just going to go ahead and share this tab instead. Bring it up for you here. Let's get started.
And the consolidated case. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Under the Act, one of America's most popular speech platforms will shut down in 9 days.
What's up,
That
Space
shouldn't
Cowboy?
happen for 3 reasons. First, TikTok
Got Jennifer in the
Incorporated
house.
is a U.S.
J-Beans
company
with us.
speaking in the United States.
We got Louis with us.
The act
Louis.
requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok speech. So the First Amendment applies. Second, the act is content-based from beginning to end. It applies only to social media platforms that have user-generated content.
Elf is in the house.
except
What's up,
for
Elf?
business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the act can't satisfy any standard of scrutiny. The government has no valid interest in preventing foreign propaganda. And its fallback that it seeks merely to prevent covertness makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's
They've
fear that
already started with
Americans,
Telegram.
even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the president-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that, in its view, reflects the best mix of content. What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture.
Look, I'm going to be completely honest with you guys. I know a lot about TikTok and the back end of it, the back working into that. Okay. We have proof with our little gang that we had before. We have proof that once they started putting U.S. employees from Los Angeles into the company, those employees started working with big creators so they couldn't get banned. Any kind of flag or anything on these big creators' accounts, even though it was a flagrant, outright, appalling breach of terms of service, you could never get them for anything because every report on their account was funneled to the people that were in the back end of their Discord. And if they had a problem with anybody, all they had to do is say, hey, what can I flag this for? The people would listen to it and say, flag it for this. We can take it down. We have 100% fucking proof of that. That's why TikTok got bad, real bad. There was like 6 fucking people that still to this day on TikTok, and Davey fucking proved it. He did. We've talked about it here on Off Label as well. There's about 6 creators that were coming up in the world with TikTok. Anytime their face is shown, it doesn't matter if it's even on somebody else's channel. Anytime their face is shown or their voice is heard, that account, if it belongs to that person, is immediately banned. There was like 3 of them that proved it. Sat there for 48 hours, making account after account after account. Every 2 hours, they would pop up. People would find them, and as soon as they did, they'd cut it. They'd shut that channel the fuck down. I had one that ran for a long time where all I was doing was taking screenshots of news articles putting them to music for like 7 seconds and posting it. I was getting flagged for things that you can't even flag for, like accuracy and integrity. They thought I was an actual real fucking journalist. They were trying to come after my account for that. I got one strike because I took a screenshot of a riot that was happening in Europe, and they had a fucking Nazi flag that they were trying to burn. That's what the riot, well, it's not what the riot was about, but somebody had placed the Nazi flag and they were trying to actually burn the flag down. And they got that for hate symbols, but that's about it. That's the only thing. As soon as my voice, I didn't even have my face pop up. As soon as my voice was on something, because I was giving a little bit of context in the back end when I said, remember when this happened? That was the only audio. My account was immediately banned. No reason given. Davey had posted a clip of this show on his TikTok. Didn't show my face, but you heard my voice. And that video was so heavily banned on his shit, he tracked the analytics on it and is like, dude, my videos usually get this, and this. This one hit absolutely fucking nothing. The next one he did pick back up in the same frame. And I was like, dude, it's because my voice. He muted my fucking voice. He edited the video, took out my voice from speaking, and it hit the same numbers again. I was like, it's me, man. My voice, my face cannot show up on TikTok unless you want a shadow banned. I'm one of those 6.
So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because
what's
because
up,
I think
Poppy
the burden
Games?
falls directly on
Hey, Joseph
TikTok. And I
Santos
can
in the house
use
with
a
this thing.
hypothetical that helps illustrate
Shane?
the point. Suppose that China used its leverage over Jeff Bezos's international empire, including his Chinese businesses, to force
Carolyn's
the
with us.
Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff
Ooh,
Bezos,
Julie
you need
Otting's
to
here
either
too.
sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos's First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access
Yeah, I
and
said hi
control
to him.
private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company
Wait, what?
operating in the United States. And it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States
Mhm.
with its own set of free speech rights.
Do you dispute the fact that ByteDance is an
With its own set of free speech rights. I got an army of motherfuckers, even after the U.S. got involved, that would say censorship got fucking worse, you dumb son of a bitch. I am one of those 6 that cannot be heard or seen on that platform without my account being banned permanently within at least a day, or anybody that puts me on their channel gets heavily shadow banned. I already told that story. You want to sit there and talk that shit? No, dude. You had U.S. employees helping the big name creators to flag whatever they wanted for and to blatantly ignore terms of service because of racism, because of transphobia, because of a lot of motherfucker. You're a goddamn company that Stephen, or not Stephen Marsh. Yeah, I think his name is Stephen Marsh, that Marsh guy. You let him come up on your platform to where he could create a Patreon where he can talk to little kids alone. And you're going to defend this? You gave us Dylan Mulvaney, you dumb son of a bitch.
Has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't
Muffin's
think it would
probably
change the
taking care of his
analysis.
family
I
right
can
now.
take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they
We'll see how that
wanted
turns out.
on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So
trading.
you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
So sure.
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say,
Look, ladies and gentlemen, my wife
Haven't been
is
very
home with
effective.
us. She is working from home. So sometimes I may have to just like be quiet while she has to take a business call. But yeah.
and be that as it may, you can say to Americans, you cannot collaborate with our enemies at all. And if you do that, you're going to be severely punished for doing
All
that.
right, we
But
can
what I
go
don't-
on to the effectiveness of the remedy, but the
Mhm.
point is, I believe that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny
Yes, Your
and
Honor.
whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What
but-
is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the DC Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
Well,
and
keep going.
you can't really take those cases and extend them to an area where there is no scarcity like the World Wide Web. Because once you do that, there's really no limiting principle. There's no reason why that wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok.
You're saying the government can regulate and it's okay because it uses bandwidth instead of printed paper. There's no way that can be a fucking argument. Especially during the first TikTok ban bill that actually turned out to be the Restrict Act, ladies and gentlemen, where they said they had full control over the internet for financial means. And if you buy, say, a game from a company that is based in another country that we deem to be an enemy, well, now you're funding terrorism. Yeah. Yeah, it was that fucking insane. So because this is an internet business, the government has the ability to regulate it because of bandwidth issue. No.
Were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making.
Oh,
the
yeah,
same
yeah, I
argument,
did.
Your Honor. There
Why,
you would-
why not?
That's a
because
story
there
I'm
you
waiting
would have
on
to
because I want to
confront
hear
a very
more.
different question, whether a foreign government that was speaking in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I
government.
understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that, all right? What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok
Wookie the
was
cookie.
totally
What's going on?
controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different.
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government.
Well,
Qatar.
I understand that, but what would be the reason for drawing that line?
Sure,
If there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States. Why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the
Right.
reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right,
but
let's
an
say that's
independent
not a
United States
complete,
company.
let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment. And if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok US has no authority.
Yeah, hold on. Shane, how would you do that, brother? How would you do that? Because if you want to talk about, let's say, the lab leak theory, well, that would be under national security, so they could be able to take it from you. How'd that turn out for us? You remember that one? My freedom of speech to be able to talk about something that is actually in the public eye, you want to take because it may be deemed national security? No.
Authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody
we do.
has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes,
It
Your Honor.
is.
The fact is that TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay, and then another fact question. Before the DC Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions. but
Sure.
I just want to understand what's before us.
What's up, Spud?
Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time.
We
frame
got
for
you, Louis.
Multiple reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of
And that's always
coordination
really been a
with that
problem,
global
though,
team
Shane.
of engineers.
But I get your
The
point.
other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States. There are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos. We understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows first what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency
Removed or
reports.
restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things where I don't know what the accusation
I
is.
have other questions about the secret evidence in this case, but we'll get to that later.
Yes,
Thank you.
Your
Mr.
Honor.
Francisco, can I ask you a question about the relevant speech here? So it strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. Well, I would say it's, the algorithm is a lot of
That's
things.
what a shared
The
culture
algorithm
for
has built within
is, or
it's
that's what a
it's
shared,
basically how we
that's what a shared culture is for. It's something for the people to say, this ain't right. You ain't doing this. Absolutely not. It would be a moral stance in this country. There are some things that should not be allowed. You know, I would 100% agree with the federal government being in that, but I also don't want them to deem something like the Hunter Biden laptop being Russian disinformation. Meanwhile, they're trying to tell you that everything about the economy and the prices is all in your head and don't believe your lying eyes. I mean, there's a problem both ways, brother. That door swings both ways for all that. It's up to the people themselves to have a shared culture to say, nah, this ain't right. We all agree with this.
predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says or say, you know, I'm hitching my wagon to China. I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm. That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
well, we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but
content manipulation by China. There was a point in time on TikTok where you couldn't even say anything about Taiwan. They would severely limit your content to where big name creators, I'm talking about huge creators on the platform with millions of fucking views per fucking video, would say Taiwan and only get 2 or 3 fucking views on that video. There was manipulation going on that shit. This dude fucking knows it.
But it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was the covertness untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level
Yes,
of
Your Honor.
the application. I'm trying to, I mean, let's say that I agree with you, the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. You know, there's disproportionate burden. Let's say
Right.
that I agree with you about that. No one is preventing you. I mean, you're seeking access to a particular.
No, you said
source
Taiwan
code,
at all. It
engineering,
was
the
done.
recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example. If we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do.
I don't know. I
is
haven't
use
dealt
an
with TikTok for
algorithm
years now.
That displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. I mean, the government is fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech. Then you have to look at whether the law itself is somehow content-based, not just what their motivations are, but whether the law is content-based. And here, the trigger for this law, the one thing that gets it
Let's see what you did there.
is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review. Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. I had understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. And if I was unclear on that, Your Honor, I apologize. That is
Okay, because I
absolutely
think
the core
what
of the
Justice
claim.
Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company, and you started off with Justice Alito saying, you know, well, we would be making a different argument, and of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. I guess my question is, how are those First Amendment rights really being implicated?
What up,
here?
Muffin?
This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture. That's not just ByteDance's choice. That is a condition
Well, I
that's
realize
imposed
that
by law.
it definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects. But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else. and leaves TikTok with the ability
Right.
to do what every other actor in the United States can do, which is go find the best available algorithm.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business, product, and travel reviews, it then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
The idea of just like,
He just
I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. You know, let's put aside like your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that as affecting TikTok as opposed to as affecting ByteDance.
Well, no, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that
That would be
China
interesting
come
to
in
see,
and
Mike.
pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like to...
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation, which doesn't have First Amendment rights. Whatever effect it has, it has. You know, maybe ByteDance will figure out a way to like put this on open source, and then TikTok will be able to use the algorithm.
So, Your Honor, if I could take that on directly, because I think TikTok has First Amendment rights. To the extent ByteDance is speaking in the United States, it, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights.
The creators would have First Amendment rights. However, it's not being applied equally because China has done the algorithm. China decides what can and cannot be done on a Chinese fucking platform that is a company based in a different fucking country altogether. They would not have First Amendment rights here in the United States. The creators would.
But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case.
That is not the case being made. It wasn't the First Amendment right as far as that goes. It was about TikTok being the initial and outright infection of dumb shit here into our culture, our airwaves, and you pushed it. Any real pushback to anything like the trans thing? Anybody remember that shit? Especially on TikTok. You said anything bad about somebody who claimed to be trans in any damn way, and you were permanently banned forever, you know? Okay, that may work. There's some food beside me. I just saw it. But it's like that kind of shit. That right there is why in the hell everybody was so pissed off about TikTok. They push shit on us like Dylan Mulvaney and that not Stephen Marsh, that whatever Jeffrey March. They pushed a whole bunch of they pushed racist people onto us. They pushed a whole bunch of different shit, and anybody that pushed back in any way didn't break terms of service, but somehow would say something kind of questionable, and they were immediately taken down. But these people could literally say kill all white people, and it's okay. Huh? You don't think that's an algorithm that shouldn't be used here in the United States of America? Okay, sir.
Yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They
I
say
understand.
these types of buildings have to
I get it.
abate asbestos.
I get that point too. The creators would have the freedom of speech. The company would have the right to promote it or not, but it is an algorithm that is detrimental to especially the mental health, which is already low, of the younger generation. I mean, the trans shit was the major vector, or TikTok was the major vector of all the trans shit and the abortion argument, because that's all you heard is pro that. That was shoved down. Anything you said about anything that was deemed to be transphobic was ripped down. Comments, videos, everything.
In addition, New York Times, you have to abate asbestos in your building, and they say there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
We think that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok.
Take it easy,
and
Elf.
The burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation?
If it's mainstream, you still have FFA that regulates our airways and shit like that.
I don't have a case in my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but
It can be done. Should it be done?
that if you're saying to
I really
a
don't
company,
think so.
you have to
But a company alone should not be the only thing that regulates what's on their platform.
and that's imposed by the force of law.
There has to be
directly affects
an
that
Internet Bill of
company's
Rights, I
speech.
guess.
Well, it's again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based,
There you go.
viewpoint-based reasons, and in particular on this record, because
That's
the
actually
speaker that
what
is
Section
ultimately being
230 is
shut
supposed
down,
to be
they
designed to
don't
do.
like the speech of that particular
But they
platform.
perverted it.
That's a real problem. So
Well, it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like Akara. And what Akara says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict
So
scrutiny.
then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly. In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on
This goes
expression,
back
whether
a
it's
lot
based on
further than
anything
that,
else.
So, Your
RP.
Honor, I disagree. And I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok, TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice,
But
Justice Alito?
What if Congress?
K-Bean, if we're going to do that, then it has to be regulated like it would be here in the United States as far as speech is concerned, because, I mean, you can't, we walk that line, but you really can't openly call for somebody's death. You know, you can't do that. So another country doesn't have to follow those guidelines. See what I'm talking about there? I get the argument. I understand. And I'm going to be completely honest with you. The Restrict Act wasn't it. You know, TikTok being like it is a mental virus as far as that goes, but TikTok was also the way we heard about East Palestine. That was it. TikTok was the only way East Palestine caught on because nobody else was speaking about it. Nobody knew. I didn't even know. And then all of a sudden, I just saw this TikTok about East Palestine, a train wreck in East Palestine carrying, you know, hazardous materials, and something should be done here. And I was like, what the fuck is this? And I looked into that shit and I was like, oh my God, this actually happened. They exploded the fucking tanks. What's all over the place? What is in it? I did a deep dive and I did a chemical fucking breakdown of every single fucking one of those punctured and exploded tanks. And yeah, that was a bad situation. That caught on because of TikTok.
Chris, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens? And they said, this is the worst offender, and we're going to require divestiture by this offender. Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Hold up. Good point,
There
Joe.
would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments.
Fair point.
I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you
Well, all right,
posited.
but you're changing the hypothetical by injecting congressional concern about the
Okay, well, I'll
content
put
of the
that to the
speech.
side.
So what would your argument be? It would be an equal protection argument?
No, I'd
Basis
still
of
be
rational
saying, I'd
basis,
still be
right?
saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have a couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties
All right,
to China.
you say, I don't want to prolong this too much. You say this is not like ACARA, I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like Arcara for a much more fundamental sense. Arcara involved a totally speech neutral law. It didn't go after speakers at all. If you had a law in Arcara that said we're going to prohibit prostitution in bookstores only, then I think that Arcara would have come out differently. There would have at least been, some kind of intermediate scrutiny, potentially strict.
All right, well,
That's the law that I think is your
walk
hypothetical.
away from the hypothetical that I
think so,
posed
Your
for the purpose of narrowing in on.
I mean, I don't
your-
know what Akara is,
what your
but
argument is. I understood you to say that that would not be a solution to the problem, because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why
everybody
Arcara is
already has
different
it.
is because Arcara didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that that would trigger, at the very least, intermediate scrutiny.
All right,
And
thank you.
Justice Sotomayor?
That comes to my question, which is.
It wouldn't happen because they have
Justice,
control of it, though.
The Chief Justice.
See the
asked you
problem?
whether or not we've ever had a case where pure ownership was at issue and not speech. And I don't think we've had one like that. You're right. But I don't think that your the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control.
Yes.
If it's about data control, and assume for the sake of argument that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, I think they'd be very similar because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could
All
unpack
right.
that a little.
No, I'm not going to,
Sure.
because we're going to run out of time, because we're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our cases have said we have to use a reasonable means.
And if I could respond to that point specifically, I completely agree it's not a least restrictive means alternative, Your Honor. But you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your
Well,
finger on.
I know you want to keep going on, but I can't let you because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am
If
not
from the record it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that, that might be
Okay,
enough.
Now
But
I take
here
that.
on the
Now let me
key-
go to the next question and the last.
If I could, Your Honor, just one sentence. If on the key less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why
because
it would
there's-
fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we
That's-
can go past
That's
that.
incorrect, actually.
No, because the NSA doesn't. What's
I'm
very
not
clear-
talking about the NSA.
Or even anything else, but putting that.
Okay, so Rick Dunner over here in the Discord, Akara versus Banks, where Margaret Akara sued Dr. Bradley Banks for allegedly disclosing her medical information during a deposition without her consent, essentially claiming that that's a violation of HIPAA privacy laws. The court ultimately decided that HIPAA does provide for private causes of actions under HIPAA. Well, that would have ended the trans argument on TikTok altogether then, because you would be giving out. Okay.
That aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is to the Chief's question and Justice Alito's questions. If the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm
A car
and
versus
promote
cloud
whatever
books,
speech it
Inc.
wants to promote through the algorithm.
It
Correct?
doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with
ask
was secret.
she about that. How do you disentangle the two things?
Thank you, Your Honor.
Justice Kate?
Oh, okay. So if it was, where was that? If it was that, a car versus Cloud Books Inc., a New York statute authorizes closure of a building found to be a public health nuisance because it was being used as a place for prostitution and lewdness. After a county deputy sheriff's undercover investigation of respondents' adult bookstores to close that the illicit sexual activities, including solicitation of prostitution, occurred on the premises, a civil complaint was filed against the respondents seeking closure of the premises under the statute. Respondents answered by allegedly inter alia. Oh, that's where that was coming from earlier. Okay. That a closure would be impermissibly interfere with the First Amendment, the right to sell books on the premises. Ah. Okay. Okay. So I see, but that I get it. That makes more sense. That makes more sense than that. All right. I got it. Okay, that's it. Well, just because you sell books, you shouldn't be able to prostitute people inside your place of business. I mean, let's just be real about that shit. That's not a First Amendment issue on that. I mean, you're running an illegal brothel. That's not a First Amendment issue. Just because the brothel sells books does not mean shit.
Justice Gorsuch? Justice Kavanaugh?
Just on the data collection interest, I think Congress and the president were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation from now will be working in the FBI or the CIA or in the State Department. Is that not a realistic assessment by Congress and the president of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they've chosen. One way, the most direct.
I can't
way to
argue
address
that.
all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the president were concerned about.
Oh, them's
You're
fighting
just saying the
words.
means they chose to address that risk were incorrect,
So I
not
have,
permissible.
I mean, I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in
It
and
needs
said,
to be
"Pass
regulated
this
within
law
our
in
laws if it needs to be within our laws. But who does that? That is the issue. Is this another country, or are we going to have to create our own company to do
And
so?
Your Honor, again, it is a concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody. Not TikTok, not ByteDance, I'm sorry, not
I'm
ByteDance,
following
not
along with the
China, not
chat.
anybody else
I
in the
can't
world.
show it.
Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it, we go dark. Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless the
Presidential
president
extension.
Right.
exercises his authority to extend it. by
Because
having-
that would
we
be
can't do that on
publisher.
January 19th. On January 19th, we still have President Biden. And on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to
I mean, yeah, sure. I think I got you in Discord here, don't I? Let me see. While this is playing, while I'm looking, hold on.
issue a preliminary injunction here and simply buy everybody a little breathing space. This is an
What do you
enormously
mean by shut down too? Can you just spell that out?
so
No, I actually don't.
the app is not available in the app stores. That's at a minimum. But in addition, what the act says is that all of the other types of service providers can't provide service either. Now, there's enormous
All right, send me a
consequences for
message when you
violating
get
that
it.
for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision, and I think all would benefit if it weren't necessary.
Thank you.
Justice Barrett?
So I just want to, it's kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok. But the law, not ByteDance.
But that's
the
because of
law requires
ByteDance's
TikTok to shut
choice,
down.
right? I mean,
Well,
this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its
Well,
motivation.
that's not quite what I'm asking. I mean,
I
let's
think
see,
I-
that's the dispute between
Yeah.
you and the government is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
What up,
And
Eric?
I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is in fact content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable. They will mix around their videos in a way that is too pro-Chinese or too anti-American.
Okay,
And that is
All right. We got Joseph Santos in the house. What's going on, brother?
Hey, dude, how you been? Long time no see. Haven't been here in a
Right.
while. Forgive me, guys. I sound a little shitty. I've been sick all fucking December and all winter, actually.
Well,
Back
don't
and
feel
forth.
bad. I mean, we just got snowed the fuck in over here, but
I'm in the part of well, I'm not in the part of California. It's on fire. But yeah, it's smoky as shit here. It was a shitty winter, honestly. Had a rough year generally, but I'm okay. All right, so this is something I wanted to say about what you guys are listening to right now. Is Amy still talking? Because I had to back out of YouTube to get over here.
Amy Comey, yeah, she's still going up.
Okay. So you heard a moment ago, she said level of scrutiny. This is something that has to be explained to you. Or it has to be explained to people generally. It's legal language. First off, under United States law, our rights were not written to jeopardize safety. The Second Amendment was not written to jeopardize safety.
Right.
So we also have in the United States Constitution the necessary and proper clause, which basically says Congress can write laws necessary and proper for safety, for security, for other reasons. Okay. Now, sometimes these two constitutional principles seem in conflict. When there's a conflict, if the argument is made the right way, eventually the court will go to an analysis called strict scrutiny, where they're going to look for something called compelling government interest. This is when the court may take an argument and agree that in order to ensure national security, a right of ours has to be restricted to some degree, even the least restrictive means necessary. That's why you're hearing that language all across this case. So people who,
Okay.
let's just say the government, Congress gets its way, and people are going to start celebrating. TikTok is losing, China is losing. No, that's not necessarily true. It depends what the court concludes after this hearing. Because compelling government interest, again, that means our rights have been restricted in some way, but only as a means necessary to do whatever the congressional law says, as a means of protecting national security. So you heard the opening statements, where TikTok's lawyers said this was not the least restrictive means necessary. That's why he's arguing that. So people are going to go back and forward to that language. That's what they're really arguing. So I just wanted to throw that out there for people who think that if the court concludes that TikTok is illegal under the circumstances, does it mean that it's a win for the United States? Necessarily, no. That's
Absolutely
not.
not. I've even made that argument myself. Like I said, there are a lot of things we can actually point back to as TikTok being bad and TikTok being good. I mean, again, East Palestine. We would have never known anything about that had it not been for TikTok. 100% honest. There are some things in our society that have come up, things that we have noticed in the background and been like, what the fuck, that have come from TikTok alone. It's a thing.
Yeah, I didn't follow all that. I believe you. I don't use social media. YouTube is really all I use. I don't use Instagram. I don't use. I don't even know if Facebook is still Facebook anymore. I definitely don't use X. I don't think I ever had an account, and if I did, I just never used it. So yeah, I don't follow these things, but the legal conversation here is more specific. If it's something that's easy to miss, if it's not, like somebody had to, that's the thing. I'm not even a lawyer myself. I have the privilege of having a constitutional professor in my family, and he's
Right.
one of those guys that won't shut up until he makes the point and wins. Okay, so that's why, that. So I have the privilege of this explanation without being charged, even though he still says I owe him $13,500 because that's the equivalent of what he would have made off me if I were actually in his classes learning.
Fuck you, dude. You're my family. No.
No, he's just dicking around.
I
But yeah,
understand. But yeah,
it's a finer point of law that goes unnoticed. In the politics of it all, that's
I mean, if
completely
you're
different.
looking at that angle, I understand. I get where this coming from. Then okay, I get it.
Right. And that's where the court is interested in separating ByteDance from TikTok. Like I said, ByteDance is out in China. So
Right.
ByteDance, because it's not under US jurisdiction, it's not under protection of the United States.
Right.
TikTok has US offices. So
Right.
TikTok is under that protection. So what the lawyers are arguing is that by this, what is superficially, this is what they're saying, that the law is superficially a restriction on ByteDance out in China, but has implications under United States law and would open doors to restrictions on free speech that are otherwise found unconstitutional. That's what they're trying to argue. Now, I already listened to this. The guys who don't know this, the Supreme Court's already shut down. They've already entered this case into the record. They've already adjourned. So we're listening to the replay right now.
Right. Because this
I
was
did
earlier
listen.
today. But
Yeah, and I listened earlier. Here's what happens. TikTok's lawyers.
hold on. I don't want to go that route because I heard a little bit about this. I never really heard every bit.
Well,
So
I'm just
don't
gonna say
spoil it
I'm
for
not
me.
satisfied with what TikTok's lawyers argued. Not because I agree with this law. I just don't agree. I didn't find that TikTok did a satisfying job of arguing against the law.
Right.
Arguing for the court to shut it down. That's where, if you saw earlier in the YouTube chat where I said I didn't think it was a good look for TikTok. That's why I said that. But you're gonna go. You could have, maybe you'll hear something I didn't hear. It was a long chat, and I had other things to do at the same time. But I'll just leave it at that. You guys are going to continue listening. But yeah, that's just something I wanted to say. People think that the court sides against TikTok if they think they're siding against China necessarily. Well, you got to wait for the determination. And yes, it's possible through this determination, if it's not handled the right way, it's possible to open doors that were not understood. Because this, based on how it's argued today, it does seem like Congress didn't do a good job separating the speech between ByteDance and what we absorb here through TikTok. So far, I haven't seen something so specific. But again, you hear the other argument. The other side is going to argue in favor of the government. And from what I gathered earlier, I'm not going to say anything too much yet, but she seemed to have more organized argument. So from my gathering, it does look like TikTok is losing this. But
Okay.
I don't know if it's for the right decision. I don't know if it's for the right reasons yet.
Well, as far as that goes, like the reason why I'm highlighting this, the reason why I wanted to hear all this argument anyway, is I understand the argument to ban TikTok, but I also understand the argument not to.
Well,
it needs to be controlled. If it's going to be a social media company within the United States, TikTok, not ByteDance, TikTok needs to be controlled and regulated like any other social media here in the United States. However, the problem is, how have we seen that being manipulated all the time on every platform?
Well, now listen to your choice of words. You said manipulated. And technically, if regulation is lawful, that's not manipulation. But if we're saying manipulated,
that's not what I'm arguing. The argument is like Zuckerberg. Let's just use him for example. The government came to him and said, "Fuck you, do what I said," and he's just like, "Sure, I'll suck and fuck you all day long." And then all of a sudden, Trump wins, and he's like, "No, I'm gonna give free speech back to you." No, Absolutely goddamn not. You knew what was going on. You happened. You kowtowed down. Now you're doing the same damn thing, and everybody's like, "Hey, let's suck and fuck this motherfucker." No, you know what I'm saying? You can't do that. Like he's only trying to get himself out of fucking trouble.
Well, you could argue he's trying to get himself out of trouble, except is that trouble even lawful? People want to blame Zuckerberg because he didn't stop people from attempting to end the
Conspiracy against
roadblocks.
rights?
Say again?
Conspiracy against rights?
Conspiracy against rights in what way?
The government went to him and said, "You shut down the shit we want, and we'll pay you for it." And he said, "Yes, sir." And then now he's just like, "Nah, the government forced me to do it." That would be a conspiracy against rights.
He said that they forced him to do it. What under what penalty?
You tell me. That ain't been talked about yet.
Then we'd be speculating, because if there's actually not a penalty,
It's all
imposed, then
speculation
we
at
can't
this
say.
point, yes, but there is no way in hell you can sit there and tell me that the federal government did not go to Facebook and or not Instagram, but Facebook and Twitter and YouTube and start saying shut this shit down. We have evidence all over the place of that.
I admit, and even give me 1 second. I need to do something.
Okay.
All right, sorry about that. I had to.
You're good.
So for some reason, when you use Restream or StreamYard on your phone, a distortion adds up, and you just got to toggle the filter. So, what was the last sentence you said?
We have evidence all over the place about the government being involved in the censorship on all social media platforms. So, I mean, that would be my argument. We would have to regulate it ourselves. However, you see how bad that regulation has gotten. Like I said, we had a group on the inside when TikTok was a thing. There was a real fucking fight being had on TikTok. We were in the inside on their Discord where we could actually prove TikTok employees were helping big creators not get banned and ban other people.
Okay. Then when the government reaches out to people, that's not unconstitutional. Whether or not the money was unlawfully handed out, that comes down to other statutes that I don't understand, and I haven't read them. Now, whether or not it was unconstitutional, that does depend on penalty. Because if the government imposes a penalty,
It is
because you will not,
unconstitutional because the government cannot regulate your speech. That's the way it's supposed to be.
that's the thing. If there's no penalty, then it doesn't amount to regulation, even if it's sketchy. It's
However,
suspect,
there
fine
is
if
some
it's fine,
regulation.
suspect.
I mean, there is some regulation to be had in speech because, I mean, freedom of speech would be anything and everything you wanted. There has to be some kind of regulation to that because it'd just be incredibly
Why do you say that?
fucking insane. Because look, we went down the whole damn trans shit with TikTok, okay? Where that was literally being pushed in every way. We got Dylan Mulvaney because of all that shit. That shit with any consent or any contesting voice was shut down. Comments removed, videos removed.
Dylan was the goofy guy in your beers, right? The
Yes.
goofy guy in your Bud Lights.
We got a whole bunch of fucked up people that were coming off TikTok, just TikTok alone, okay? That were actually just they were literally spreading the misinformation that everybody's arguing about with that shit, okay? If you're talking about that, there is no way that a contending voice needs to be shut down unless it does violate some kinds of terms of service, like I'm going to kill you or something like that,
In terms of service, remember that's privately decided, and that's still.
And that's the problem, though. That would be the problem. The terms of service is privately decided within the company. Okay, so the company can say that there is no contending voice in anything that they deem to push out there, like the trans issue.
And you can do the same thing here. You could just kick me out right now. You control the little red button that says "Get out." I got nothing to do with it. I'm a guest in your house right now. The same rules. Well, then you understand it's the same constitutional rules. And as much as people don't like characters like Dylan Mulvaney, people are similar who talk similar talking points, similar propaganda or not, any truth of the matters asserted, faith, religious doctrine, history, historical disputes. These are all protected speech. Obviously, people don't like it. That's fine if they don't like it. They also don't have to listen to it.
Right.
That's just how that is how it works. And people are looking for exceptions to free speech because what people are really looking for is priority over others instead of admitting you're just an equal. We know social media was very biased for years. Unfortunately, there's money in it. As long as there's money in it, they're going to do it. That's a free market principle. That's the First Amendment principle. That's just stuff that
Yeah.
people got to learn to live with. I can tell you. Remember, I want you to know this, and it's reflected in the recent election polls. 'Cause I do other streams, especially actually it's on a liberal channel, believe it or not. And I have said for years, the conversation on the internet, especially about California, is very different from the conversation on the streets. When you're
Right.
talking to people directly, the voices you hear, the words you hear are very different from what you see online.
Right.
And if you keep giving them priority, if you just look to what you see on the internet, you're not going to understand the conversation. And that fooled people, especially on the left, because there's this talk about a culture war, and they kept saying, "You, everybody else, you're the independents, the conservatives, the libertarians, you all lost the culture war." And then you saw the recent election polls. You saw the recent outcome with the federal government. And that's a reflection of what I've been saying. What people are saying on the streets is different from what they say online anyway. The people are putting too much weight on the internet. They're putting too much emphasis on these platforms. Unfortunately, the reason that have a key reason I see actually, some people are too concerned with the internet. For a lot of people, that's really what they have most in this world. And that's really unfortunate. When people let that go, put that down, and just go and talk to people and hear what they have to say for real. It's
Oh, yeah.
different. And now whether or not people like it, again, doesn't matter if it's Chinese propaganda, it doesn't matter if you're afraid of being ruled by a foreign church, whatever that stuff, okay? You know the stuff I'm talking about. It doesn't
Right.
matter. Okay. The
I
truth,
mean,
this is ultimately, guys, the value of our amendments, of our Bill of Rights. Any truth of these matters asserted belongs to us, and it cannot be forced away from us by others. No man, woman, or child can force it against you. Not government, not the average person, nobody, nothing. That's ultimately the value of this. People are giving this too much attention. People are giving the tensions too much attention. What you should be doing instead, if you care about your rights the most, if you want to exercise them and prove they still exist, they still have value, use them to find the truth. Not just
Right.
the convenient truth, just the truth. Any truth, any inconvenient truth. Okay, that's how you exercise them, and that's all because that's the highest value in these rights that are protected. Any
Right.
truth that we find just belongs to us, and that does mean a bunch of bullshit's got to fly around. Some of it's going to stick for a while. It's going to get stinky. that's
I mean,
just the
just
nature of it.
case in point, the whole damn what is it, the Matt Gates thing. I was just like, nah, I don't really believe that. It could be possible because the man is young. You know, he is a good looking man. He looks like Jack Nicholson in his young days.
Good looking. You're fucking with me. No, you had
He,
too much to drink.
I haven't had a single thing to drink right now.
That sounds like something a drunk man would say, sir. I need you to close the mini fridge.
No, but I mean, I can see how that he looks better
He
than
looks
most
like
people in
Beavis
Congress.
and Butthead combined. He's
He looks
got
better than most
Beavis's
people in
underbite and
Congress.
Butthead's hair.
I understand. I make the argument all the time. He looks like Jack Nicholson in his young days, and he straight up does. He looks like the fucking like Jack
I
Nicholson,
wish I could show you
younger
this.
Jack Nicholson Joker.
I can't find the photo anymore. There's this toilet coffee mug where the
But
toilet's teeth, the lower teeth, are protruding like Beavis, like Matt Gates. I swear they look exactly the same. But whatever the case of that, here's also something people need
but
to
I do want to
grasp about.
say I honestly I bring that up because I do want to say I'm honestly starting to think maybe there is a lot of truth to what's happening because the dude was just like fight. This comes up and he's like, nah, I'm just gonna back down now. But just like, okay. Then it was released anyway, and I'm just like, there might have been some truth to this. You know, you got Madison Cawthorn sitting there saying they're having like sex orgies underneath fucking the Capitol building, you know?
They put forward financial records.
Yeah.
Okay, so there's truth to it, but the same thing, and that's really what the kind of stuff I'm trying to say right now. Discretion is yours. Any guesswork is yours. Any facts, any statements of fact that stand out to you for personal reasons, whatever. Yeah, that's all yours, but it's also someone else's,
Right.
whether or not you like them.
Right.
And now my point being though, because what protects the other guy, the guy you don't like, is also what protects you. If this case is handled the wrong way, Congress will see a right to regulate speech in a way that in writing is not permissible.
Mm-hmm.
And then we have another problem. We have another set of problems. So I just wanted to present that for people to understand that language like compelling government interest, especially strict scrutiny, this is language you really don't want to hear in the Supreme Court, because this is iffy territory. Now, listen to that language, that strict scrutiny or compelling government interest. This is where the government is arguing that the only way to protect national security is to restrict rights at least in a very light way. And that's what the courts have affirmed, that if compelling government interest is applied, then that means the government has to use the least restrictive means necessary. And if the courts disagree on what least restrictive means necessary is, meanwhile, we here, the people, are going to struggle with whether or not our rights are fading at the same time. And that's very important for people to track. This first, to my understanding, the first big conversation in the court where this came up was Nixon versus the Washington Post. The Washington Post exposed him, and Nixon's lawyer said, for national security reasons, we have to stop the presses. And the case went to the Supreme Court. The Supreme Court said this is too vague for compelling government interest. You can't just say national security concerns over and over in a vague way and then expect the court to restrict the rights of the people to speech and the press. That's not sufficient. There has to be evidence of some kind of imminent or some kind of provable threat.
Right.
Okay. Now that's where that language came up. Those principles are still governing what compelling government interest is. The fact that we are listening today to a case about compelling government interest is ultimately the highest concern. Never mind TikTok, never mind how liberal TikTok is, whatever people think liberalism is. I use that now just because it's easier in conversation, but there's nothing liberal about them. There's no liberation in anything these people espouse. Period. But what people should really be listening for is whether or not the court is going to agree to a restriction on rights for national security purposes, and whether or not there really is a national security purpose at the time. Just because people don't like China doesn't mean that speech needs to be regulated.
Yeah, like the Hunter Biden laptop story. Like the Hunter Biden laptop story. Just because it was something that is detrimental to national security, you could argue that we need to pull that back, even though, hey, there's a lot of evidence that said it would have changed the course of the election.
He was employed by the government at the time, wasn't he?
Who?
Because if he was employed, that's different. Because remember, we're not employed by the government.
So no, I'm talking about who. Who was employed?
Hunter.
No,
he wasn't employed at the time. Okay, then that's different. That I didn't follow every step of the way. My whole thing is it's the same thing with with anybody. Same thing with Trump. Same thing with Gates. Same thing with Hunter. Lock him up or don't. I got tired of hearing.
No. I'm not trying to bring that up. I'm not trying to bring that up. I'm just telling you. Okay, here's
I can't follow
the story. The story with that though was he had dropped the laptop off for repair at a repair shop. Did not pick it up. So by the repair shop rules is, hey, you haven't brought it for 90 days. How am I going to get paid? Okay, fine.
Right.
I'll take everything off the hard drive. I'll clone the hard drive. I'll wipe it. I'll put it on my shelf for sale. When he was looking into it, he found out that it was Hunter Biden's fucking laptop, and there's a whole bunch of incriminating fucking evidence and a lot of fucked up shit on there with a whole bunch of emails that track back down to foreign interference. He gives the hard drive to the FBI. The FBI had everything in 2019. And then
other
all of a
than
sudden that comes up and the story goes off into the whole, oh, New York Post gets the information. They're going to run the story. And then FBI starts going to the major platforms. You know, you got X, YouTube, Facebook, things like that. Well, it was Twitter back then, and said you're going to see things that have all the earmarks of Russian disinformation, and we need you to shut it down. And then there was direct collusion within the Twitter files. There was direct collusion between our government to shut down speech. So yeah, there is a lot of that. We haven't seen it with YouTube
did
yet
the
because
Supreme Court
YouTube is
ever weigh in on this, or at least the federal courts have weighed in on this, right? But has the Supreme Court
on the
Hunter Biden laptop issue?
I honestly I don't know if it made it to the Supreme Court with that.
Here's for a lot of things we shouldn't really need the Supreme Court. The Supreme Court is, at least the way law has been practiced, the Supreme Court is really only supposed to do anything if the lower courts disagree. In this case right here, my understanding is the lower courts didn't disagree. The two lower federal courts agreed with the government on this. But the issue is still being pressed. Usually they don't. So there must be something in here that the Supreme Court believes the lower courts have missed.
I mean, there's a lot in that as far as that goes. There's a lot that has been missed, but I get your point. Yeah.
Well, whenever you're talking a fundamental issue like our rights, especially ours, because it's always our speech that they go after.
Yeah.
Right? It's always our speech. It's for some reason. Everything else generally gets left alone, but it's really our speech they go after first, right?
Right.
But anyway, it's a fundamental issue. When it's a fundamental issue, there's always going to be more to the story.
All right.
Give any of these stories more time, you're always going to learn something else. You know, you're always going to learn more. Like you said, I believe this is towards the end of TikTok's lawyers. So this is they go back and forward. The government lawyers are next. You'll know it's a woman's voice talking. When it comes to matters like this, when it goes to the court, the argument.
Wait, what? Hold on, because you can tell because it's a woman's voice talking. What?
Yeah, I'm letting you know because the lawyer for the government, the representation for the government is a woman.
Oh, okay.
That's why I said that.
Okay, I was like, so we're just gonna switch gears because a woman's talking? Is this it?
No. Sorry. Anyway, there's good reason this matters.
Okay.
The arguments that are made before the court today are the ones the courts are going to consider, assuming the court is acting in good faith. They're going to listen to the words spoken today, the words put on the official record today. They're going to piece that together. You have there are other clerks at the courthouse that do research for the justices. So it's never just the justices alone.
Right.
A lot is going to go into this based on the court record today and existing court precedent. So lots of things written today, and they're going to look at whether or not these arguments today either prove that the First Amendment is being restricted in an unreasonable way, or that the First Amendment is being restricted in a reasonable way. That if they're acting in good faith, they're looking at the arguments made today. So if the arguments made today suck, and the courts make a determination from there, it could have very detrimental effects on any forthcoming legal doctrines, legal documents, not the word I'm looking for. Any law that is coming forward soon.
Right.
It has implications for the future. It has implications for the past. Because remember, this was finalized in 1791. So this can have implications for all kinds of laws that we even attempted in the past, and this will ultimately shut down. So everything that is said today matters, because if it's a shitty argument and the court agrees with a shitty argument, then we deal with shitty results. So it's actually a lot more sensitive than people I think understand. It's stuff that people will miss if all they do is read the headlines and read articles about this. It's stuff that's really hard to understand if somebody who knows better doesn't actually explain it to you. So I just wanted to throw that out there so you guys can see there's a lot more weight in this conversation than you think. It's not about the U.S. versus China. It's not
I understand it now.
Oh, I know whether or not it's your words, just a lot of people listening to that. It's
Right.
not about sides necessarily. It ultimately, yeah, you can argue it's about sides, but it's us against the government still. Never mind your opinion of China. Ultimately, this comes down to people versus the United States government, because this is the United States government, the Supreme Court, determining whether or not our right is going to be reasonably restricted. And that language should stand out to you, that should irritate you, that should alarm you, because the Constitution doesn't say anything about reasonable restrictions to our rights. But this is
Yeah.
a practice that has been going on in law since 1803.
And
And it's
case
going
in
to
point,
continue, and it doesn't have a limiting principle. So
right.
that's the real importance here. What you should be judging is whether or not the court is doing whether or not the court is doing the right thing and protecting our rights. That's ultimately what people should be listening for. So that's really what I had to say about that.
I understand, and you are right. There is no way you would have been able to type all that out and have that make sense. I get what you're saying. I do, and I in a broad sense, yeah. Okay, I can see it in a broader sense as to what your argument would be. This isn't about TikTok. This is about the government saying, "Yeah, we're going to curtail your rights, and for this reason."
Hmm.
Okay, I get what you're arguing with that. Okay.
Well, that I'm bringing that to you because that ultimately is what this conversation in the court is about. They're answering constitutional questions, so they're answering fundamental questions. So that's why you're seeing it in that wider sense, because this is a fundamental question. Okay, now, here's also the part that should be alarming. When if the let's say the government says certain speech is not protected, first off, that should alarm you right away, because the Constitution doesn't say protected speech shall not be infringed. It just says
Right.
speech.
Right.
Anyway, if certain speech is for some reason considered not protected, that comes down to a category that gets organized into a category. And if the Supreme Court says a category of speech is not constitutionally protected, then that means state or federal governments can apply restrictions, or they can protect it through a statute. But
Right.
in all likelihood, they're going to apply a restriction because they need the vote so they can come after. They need the vote now so they can come after us later. That's all they want to do. So that's, and like I said, that's more important. That's really the fundamental question. Is this really the right thing to do? Is the court really going to allow a restriction that is narrowly tailored to national security only? And listening to this, I have to listen to it again. These conversations are always long. They're all at least 2 hours. I've seen some that
Right.
go to about 5.
Yeah, I did one
I'd
for
have
like
to-
6.5 hours.
So yeah, they can go on a while. And I think this hearing is there are actually two. No, there's another hearing Monday. Sorry. So anyway, yeah, those questions are really important.
Right.
And yeah, that's just stuff like that goes unnoticed if people don't actually have it explained to them. So that's all I really wanted to say.
I understand. I appreciate you actually breaking it down even further.
Right, so that's right. I'm gonna get out of here. I actually have other stuff to do. So going forward, if anybody is still on it, I know it's a long talk, but you have a dedicated fan base. So that's really the stuff you want to listen for. It's
Right.
not, it's not a question of whether or not you agree with China. Leave China out of it for the most part. What people should be listening for is whether or not the court is reasonably going to apply a restriction for national security without restricting your right unreasonably. And I don't know. I have an issue with those doctrines, compelling government interests.
Right.
They make sense to a very narrow point, under imminent circumstances, but when it comes down to reasonable, what is reasonable? Ultimately, the court gets to decide that. How you doing, Jennifer? Ultimately, the court gets to decide that, and there is no limiting principle. So
Okay.
it's alarming. So that's why I listen to stuff like this, and that's what you guys should be listening for. Not the question of TikTok or whether or not it's ByteDance. What you should be listening, whether or not the court is doing the right thing, protecting our rights and our security at the same time.
Right.
That's something I just wanted to introduce as you guys go forward.
And for everybody that doesn't know here, Joe is the person that like he easily gets underneath my skin because he makes arguments that I know he knows are unreasonable as fuck.
I
Joe's
fuck
an
with you 'cause
incredibly
it's easy.
smart man, but he's able to get up underneath my skin quick as fuck.
No, you make it easy.
I know I do.
I'm
Because
actually
I know
really polite.
I know you're just playing stupid, and that's the problem for me.
I'm actually a really polite guy. You just make it easy. I get no. It's a Latino thing. If we know it bothers you, we keep it going. We're just gonna keep bugging you a little bit. I know Davey does.
It's an asshole thing. I do it too. But yeah.
All right. So I've said what I needed to say.
All right.
I'm gonna step down. I got other stuff to do. Go ahead and enjoy the rest of the show, guys. I'll see you around next time, Mitch.
Appreciate it, man. All right, let's go back to that. I like Joe. I really do, because he's gonna think of an angle that somebody else hasn't, and he's gonna poke and prod at you. I love Joe. But yeah, let's get back to this here, because like I said, he brought up a different argument that I really haven't heard anybody really make about it. I'll take that into account as we move forward.
TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But
and
that's what
executed
Justice
in the
Gorsuch
code.
said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source.
So, well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say, we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations. And the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture. So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says that TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post divestiture or whatever, pre-divestiture, come up with its own algorithm, right? Then when the divestiture happened, it could still operate. It doesn't say TikTok
TikTok, you
I think
can't
that's
speak.
theoretically correct, Your Honor, but I
Right,
think that
but-
also underscores the content-based.
Hold on, guys. I'm gonna take a little bit of a I got a Rumble segment. Mark Zuckerberg and Joe Rogan again. This is gonna be a long day. Anyway, let's go back.
Nature of the restriction.
No,
We have
but
to
the fact,
change our
excuse me, the
speech.
fact that that's true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
You
Your
wrong
Honor,
for
I
that,
think it is
Jennifer.
partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
And ultimately upheld the law, so fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok incorporated speech.
All right, I think I
wholly
understand
apart
that
from
argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean,
They have to engage in speech that they don't want to engage in. I'm just going to bring it back to the whole culture part of it. So saying that a trans woman is not a woman is engaging in speech that they don't want to engage in, so therefore that they should be allowed to take that down. Now, that's not the argument the man was making in that point, but it's the argument that I would make for the company itself. As far as that is engaging in speech that you don't want to engage in, so therefore you have the right to regulate that. It's a private company. They can do what they want, but that would be detrimental to any kind of Section 230 covering at that point, because then you become a publication. Different argument for a different time.
and you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security. And two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating, we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content. And I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content.
Yeah.
That is core protected speech.
Yeah.
That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content based versus content neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming that you're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in colloquy with Justice Kavanaugh to say is a risk. And we are concerned, based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not a compelling governmental interest. It is an impermissible governmental interest. You could not go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like. That is per se impermissible.
Okay, can I just ask you one last thing? You say, with respect to the tailoring issue, that disclosure, you think, is a possible, more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications. That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong.
I have no idea where she's trying to go with this.
Right. And if the factual predicate is right, then there are no First Amendment problems at all under Zauder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are. But you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even
That's what Rick was talking about.
in the first place.
Yes,
the bare
Jennifer.
minimum that has to be done before we take an unprecedented step of shutting down the voices of 170 million Americans.
Thank you.
Thank you, counsel. Mr. Fisher.
I'm going to make the joke. I've been thinking about it here for a second. I'm going to make it. Do you think it was intentional? Intentional? Do you think it was an intentional thing that they let the black woman go first or go last? I'm sorry. I just had to make that fucking. No, of course not. But I can't. That was a dumbass argument. Like, you got your ass spanked with that. That was. But hey, coming from a woman who can't tell you what a biological woman is, that sounds about right. Let's get set up for the next one.
Fisher?
Mr. Chief Justice, and may it please the court, wholly apart from the company's legal
No
interests
Rosa
here,
Parks.
the act directly restricts the rights, the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the act, therefore, is inescapably subject to strict scrutiny because of the First
Take
Amendment
it easy, Jennifer.
implications. And the act fails that test, and indeed any level of scrutiny under this court's case law, because the act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we've faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly are the creator's speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates
I'm still here,
text,
everybody.
images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other
But it
Americans.
doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with
using that
particular publisher.
argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, look, I think that you have to dig
British
a little deeper than that,
Broadcasting
Justice
Channel?
Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States? I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right, so I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine US leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism? Is it where our battleships are located?
Justice Kavanaugh presented a number of potential risks, right? With foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security, or could it reasonably be worried about data security? You say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy.
Okay.
They're not saying TikTok has to stop. They're saying the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again,
Right.
Mr. Chief Justice, if I may, let me separate the where you started, which was the content manipulation, and then go to the data security part of it. So,
well, the
I
first part,
understand-
I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's
They've
data,
got
or
all the information, whatever algorithms they want, that has access to the personal information, or at least information that is not readily available about 170 million Americans. And whether they're going to use it in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now. That, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says, what we're really worried about is sowing doubts about US leaders, et cetera. So let me turn then to data security.
You got a point.
There were various congresspersons, and in the record that we have in the DC Circuit, there were conversation about the problem of data security here. As I said, I don't dispute that that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it, and every bit the connection?
Does Congress have to go all or nothing on that? I
Him too. That's why you see me bounce over the screen real quick. I'm taking a bite.
Particular problem, and they might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
So I'm saying
I
it would not have passed this divestiture law if data security were the only interest. It's very curious why you just single out TikTok alone and not other companies with tens of millions of people having their own data taken, in the process of engaging with those websites, and equally, if not more, available to Chinese control. So I'm not trying to say that Congress has to do everything at once. I'm trying to say that once you've concluded that content manipulation, for the reasons I've said, as a matter of our history and tradition, has to be impermissible.
Is there another site like
Oh, come on.
that covers half the American population?
No.
I don't.
Kagan, he was making a strong fucking argument. He was making a strong fucking argument. You do it to TikTok, you're going to have to do it everywhere else too for any other fucking company that has to do with anything of social media or financial. Wow. I mean, that was a strong argument. I'm not going to lie.
I think just by way of sheer numbers, Justice Sotomayor, that the answer has to be no, but 70 billion seems like a lot.
170 million is a lot, but put that aside and then go to the next question, which is, how many of these sites have all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission to access your contact list, whether that contact list has permitted them to or not. So they can now have data about all of your contacts and anything you say about them. How many other sites gather information by keystrokes to be able to do voice and finger ID information if they choose? There's a whole lot of data stuff that was discussed in the brief that
Now fuck
I
it
don't
up
think
for us,
any other
Kagan.
website gathers. So wouldn't this be a unique site? If I viewed the evidence that way, how would this be under-inclusive?
Justice Sotomayor, I don't think a lot of the suppositions you're making actually bear out. And as Justice Gorsuch was pointing out, one of the obviously the real challenges in this case is it comes to you without an ordinary trial record compiled and all the rest. So we have only limited amounts of information, but absolutely these other websites are taking much the same kind of information, if not more. And as to the contact list thing, I think that points out one other aspect of this. That is voluntary decision by an American user to share that information. In the Riley
But
case.
not informed. And
Well,
even if
that could be
informed,
solved. If you don't think it's informed, that could be solved
well,
by
no,
a
they
warning
can't
or
be,
disclosure.
because for the United States, the threat of using that information is what is at issue. It's not whether the user thinks it's okay. It's whether the U.S. believes that it could put sites at issue. But let me ask you one last question and fundamental question. Assuming
Shout out to what
that
Joseph Santos was saying.
that content neutral data collection concerns were is one of Congress's provisions, divest because of this. Why can't we separate that out from how we analyze the algorithm question? And couldn't we sever the two provisions to say divestiture is right, but you can't force them not to discuss algorithm?
Well, I think the reason why you can't do that was Mr. Francisco explained. I thought I'd direct you to a case like Hunter against Underwood and just analogize it to this situation. If what you had is the government saying, we are shutting down TikTok or requiring divestiture for two reasons. One, because we think it helps the Democratic Party too much. And number two, because we're concerned about data. I think that first interest would be a poison pill. That would be an impermissible, or because we think there's too much pro-Catholic content on TikTok. I think there are some interests that are just so constitutionally verboten that I think that just makes the act unconstitutional, and you can't go looking for other interests. You send it back to Congress. Look, if you want to pass a data security law free and clear of this impermissible interest, you go ahead and do it. So, can I say one other thing, Justice Sotomayor, just because I think it is also telling here that even if you didn't buy that poison pill argument and you just asked whether Congress would have passed this law, something else that I think you might notice is Even if all this act goes into effect and the law goes through, TikTok gets to keep all the data. So wouldn't the data security law require them to expunge that data or get rid of it or something? I mean, it's a very weird law if you're just looking at it through a data security lens, and maybe Congress could do better.
Mr. Fisher, often we require divestiture for antitrust reasons, for example. And as I take it, your argument here, and we don't think of those as normally implicating the First Amendment interests of users or people who might speak or associate with editors. And the difference here is, as I understand it, in your mind, that this law is
Okay, I get what you're saying now.
Content-based interest. Is that a fair summary?
I think that, and the only thing I would add to it is just the prior step, which it is regulating the speech itself for content-based reasons.
Yeah,
Yes.
and we don't do that in the antitrust area, but you say this law does. Okay.
Exactly.
And it does on the covert content manipulation side. Do you think that's a compelling interest or not? Forget about the tailoring for a moment.
No, my point is that
Cat lady
preventing content
security matter.
manipulation, whether it's covert or not,
Is simply
is
not
impermissible if what you mean by content manipulation are the kinds of interests the government is saying, like undermining trust in our leaders,
And
undermining
that's
trust in
Whitney and
democracy.
Abrams in your
That's Whitney and Abrams, and like those cases.
I got it. I got it.
So, Mr. Fisher,
Just a couple more. I'm sorry. I'll finish up real quick. And so that would take us to the tailoring question. And there you say disclosure and alerting Americans that there is covert content manipulation possibility, putting aside the data collection part of it.
Yeah.
Telling Americans that there is covert content manipulation going on in TikTok, or at least it's possible. And the government says that's just simply not enough. And the DC Circuit did too. And I wanted to give you a chance to respond to that.
Right. So I think that's the only aspect of the governmental interest that could be permissible, the covert part. And my answer, as you just said, is disclosure solves that problem. And you have a longstanding law, which we haven't talked about yet today, that gives you that example. Again, under a history and tradition test, you look at not just precedent, but laws and our traditions of our country. Look at the Foreign Agent Registration Act, passed in the run-up to World War II. And the concern was Americans would be controlled by foreign agents to speak and advocate certain causes.
We didn't ban them.
You did not ban them. All you did is require, Congress, all Congress did was require disclosure.
Certainly I wasn't around for that. On the secret evidence point, I'm concerned about the government's attempt to lodge secret evidence in this case without providing any mechanism for opposing counsel to review it. And I expressed that concern in Zebeda, and I noted that there are mechanisms to read in counsel and that other countries, including our allies, often do that. I just wanted to give you a chance to give me your thoughts on that.
Yes, Justice Gorsuch, we made all those arguments in the DC Circuit, so there was a flurry of motion practice about whether or not the government could rely on classified evidence. Those motions were never resolved. What the DC Circuit did, I think you probably noticed from the decision, is say we're going to decide this case solely based on the public record. And my understanding is that's how it comes to this court.
It's
But if the court were ever
It's interesting that Congress hasn't acted in this field. I mean, we have in the FISA area, lots of opportunity. They have regulated this area, and it does seem like an area that Congress might want to pay attention to, given the increased appeals to secret evidence that the government has made in recent years. Last question for you. Could the new administration, after January 20th, Mr. Francisco suggested that it might be able to extend the deadline, even though if you were to lose here by January 19th? Is that possible as you read the law?
I'm not sure it is. I'm not sure. Maybe that's a question for the Solicitor General. But
it certainly is. I thought maybe I'd give you a chance too.
So, as I understand the law, it's 270 days unless extended. And once that time runs, I'm not sure you're talking about an extension anymore.
Okay.
There's ex post facto law that kind of does this stuff.
Thank you.
Can I take you back, Mr. Fisher? Let's say I agree with you that if you're talking about content manipulation, that's an inherently content-based rationale for acting. So if Congress had passed a law that says we hate the content manipulation that TikTok is doing, that's strict scrutiny land, and I don't know that the government can do that, however important and the interest. But that's not what Congress is doing here, and this is the same kinds of questions that I asked Mr. Francisco, because if let's take it as a given that Congress actually can do whatever it wants with respect to a wholly foreign corporation or a foreign government.
I'm
And
sorry,
so
what?
Congress could act with the intent to interfere with the content manipulation that a foreign corporation is doing. And so now we're in this strange world where we're saying they can't act with respect to TikTok. They could act with respect to ByteDance. Why isn't this Congress acting with respect to ByteDance in the sense that all it's doing is saying ByteDance has to divest, and then TikTok can go about its business, use whatever algorithm it wants, use whatever content moderation policies it wants, just like everybody else does, choosing from everything that's available on the open market?
So let me answer that question in two parts from the perspective of the creator Americans who want to use this platform to speak to other Americans. So the first thing is what the act does, as you said, Justice Kagan, is prevent us from working with a application that is owned by ByteDance that uses this algorithm. Well, that's exactly what we want to do. That's our editor and publisher of choice that we think best disseminates our speech.
Yeah, but what I'm saying to you is if you just assume a world without TikTok, that where it's only ByteDance, and you were trying to say, well, we really want to work with ByteDance, and Congress was saying, we think ByteDance presents national security interests, and they don't have First Amendment rights. They're just a foreign corporation. I think that in that case, the government, I mean, tell me if you think this is wrong. It just doesn't matter that you have creators who want to work with ByteDance because ByteDance is a foreign corporation with no First Amendment rights. Is that what you're contesting?
So that is what I'm contesting. So you said two things, though, so I could be clear. There's two aspects. Do we have a First Amendment right to work with a foreign company or even a foreign country to publish our speech? And then there's a national security part that you put into that, which goes to the justification.
Forget that.
Forget that, yes, let's do that. So if that is right, Justice Kagan, then American creators have no right to make documentaries with the BBC. They can't work with Al Jazeera if Congress wants to prevent that. Any number of other publications that are state-owned wholly or partially. And even under Lamont, remember, where you're not even creating speech, you're just listening. You know, that was speech from China that the court said you have a First Amendment right to
Would I be
receive.
right to say that your position is that because of the users who want to associate and want to partner with this foreign corporation, the foreign corporation ends up having, in your view, the exact same First Amendment rights as your users do? In other words, it's irrelevant that the foreign corporation doesn't have First Amendment rights.
I don't think it's irrelevant because you could imagine a situation where no American distributor or speaker wants to work with that. But let me put it to you this way. The Communist Manifesto written by Karl Marx has no First Amendment standing on its own in America. But if a bookstore wants to sell that publication, I don't think Congress can prevent it from doing so.
Well,
I don't either.
Sorry. Go ahead.
No, I'm fine.
No.
I'm good.
Okay. So I want to press you a little bit on the distinction because in Lamont, the prohibition worked directly on the American. Like you have to specifically request this information that comes. This is working kind of as Justice Kagan's questions were pressing you. This is working on ByteDance. It's not saying to your creators, you can't post on ByteDance. That's indirectly going to happen if ByteDance chooses itself not to permit TikTok to walk away with the code. So does that matter, that distinction between Lamont and this case?
No, for two reasons. One, under the Sorrell case, you look to not just the law itself, but its practical operation. And the practical operation is prevent us from working with ByteDance. So that's one answer. And you bring up Lamont, and Lamont's actually a very important case, I'm sure you all recognize here. It's important to look not just at the court's opinion, but look at the briefing in that case. The government itself never came in and argued there's no right to receive this information. That's the sort of greater argument. All the government argued was, of course, Americans have a right to receive this, but it's just not so much of a burden to require them to raise their hand to get it. So Archibald Cox, when he was the Solicitor General, said to the court quite explicitly in the brief, we're not even going to make this argument because we think it's so contrary to history and tradition. All we're going to argue is the burden isn't enough. Now, what happened is the DC Circuit kind of turned that upside down and said, oh, Lamont's just a case about the burden. Well, that's because that's the only argument the government was even willing to make in this court. There was no argument that Americans didn't have the right to hear that speech.
What about, so I think this goes to Justice Gorsuch's questions about antitrust divestiture. Let's say that let's say that for antitrust reasons, or let's even say not for that. Let's say for suspect First Amendment reasons, Congress tells Jeff Bezos that he has to divest in the Washington Post. You know, he can no longer own the Post. And let's say that neither Bezos nor the Post challenges that. But let's say that you represent clients who really like the Post as it was, who really want to keep receiving the Post, who really want to publish op-eds in the Post.
Yep.
Would you have standing? Like, what kind of a claim would you be making there?
I believe so, Justice Barrett, and the court has cited Lamont and other cases in more recent years to say we've recognized a right of American listeners to receive information from others. And remember, even that is a lot. That's only a small part of the argument I'm making on behalf of the creators. You know, I don't mean to diminish Mr. Francisco's arguments on behalf of the company and ByteDance, but the core speech in front of you in this case are the videos and other forms of communication that people like my clients are posting by the millions every day on this platform to share with other Americans.
Can you win is it possible for you to win and Mr. Francisco to lose, or you rise or fall together?
No, I think it's possible. I mean, I don't think we should. But
was it possible for you to win and him to lose? I mean,
well, let me put it this way. If you were to conclude that something about the corporate ownership structure, and I think there was some conversation about this earlier, impeded Mr. Francisco from being able to assert full-throated First Amendment rights in this case, I would step in and say, well, certainly we can do that and get you to the strict scrutiny. And then the arguments pretty much line up. Then you're in a question of, can the government satisfy strict scrutiny? And I think, Mr. Chief Justice, you asked about, do we have cases for this and that? I think that the idea is, yes, we have cases that say, once you're in strict scrutiny, that regulating the content because you don't think it's going to be pro-American enough or it's going to be too pro-foreign interest is just verboten under the First Amendment. That's the history and tradition. And Justice Kavanaugh, when you asked about the broadcast cases, they're grounded not just in scarcity, but they're grounded in scarcity in a particular way. It has to do with the absolute need Congress has for licensing in a world of scarce resources. And so that's the very small carve out that even in Turner, the court wouldn't extend to cable television that exists for broadcast licensing. And if you look on the 200 plus years of our country for any other example of foreign ownership of media being regulated by Congress, let alone being permitted in the case law, you are not going to find it. And I think the reason why is because everybody has understood that if you're not in a world of scarcity where licensing is impossible, you cannot give the government, and in this more extreme example, the president himself, unbridled discretion to choose who is a proper owner of a speech platform in this country, because it is so hand in hand with viewpoint. As I said earlier, any number of owners of big media enterprises, whether they be Americans or foreign citizens, could be accused of having a particular viewpoint, but speakers who engage in those platforms have choices they can make. And so, you know, on behalf of our creator clients, we find it not at all satisfactory to be told, well, look, just go post somewhere else. You know, it's not enough to tell a writer, well, you can't publish an op-ed in the Wall Street Journal because you can publish it in the New York Times instead. Just like here to say, you can publish it on Instagram or some other platform, not just TikTok. TikTok has a distinct editorial and publicational perspective, and it particularly benefits people like my clients who are not famous people, they're not actors from Hollywood who have a lot of people following them, they're ordinary American citizens whose content that they create on the platform gets privileged by way of the quality of that content. And that's what's so powerful about the platform.
Or privileged by quality of way of the government itself. I mean, let's not forget Biden hiring TikTok stars to push propaganda on us. Come on, that's government influence in the app itself. So I don't know, but I don't like that argument. I don't like that argument he just made with that because that's bullshit. It straight up is just because they're regular Americans. Okay, so you want to talk about what was that? The Russian Times with Tenet Media, all that shit. You want to go back? We can make that argument. What's up, neurodivergent?
So whether you're an ordinary American
Bean's
citizen,
back.
or I might add, whether you're a presidential candidate in our last election, if you want to reach new and different audiences, TikTok is the place people go.
This may not make any difference for constitutional purposes, but just out of curiosity, I'd like you to explain what the practical consequences would likely be for your clients if TikTok went dark, as Mr. Francisco put it. There, I assume, is a great demand for what TikTok provides. And if TikTok was no longer there to provide what your clients really want,
As
is
good as
there
I
a
can
reason
be.
to doubt
I'm
that
listening to
some
this,
other
and
social media company
Joe
would
put me
not
on another
jump
track
in
with my thinking with it.
and
But yeah,
take
I get what he was
advantage
saying.
of this very lucrative market?
There are two reasons, Justice Alito. One is many of the declarations from my clients actually explain they've tried on other platforms to generate the kind of audience and engagement they've been able to on TikTok, and they've fallen dramatically.
Yeah, I know they haven't so far, and I'm just, I'm just wondering whether this is like somebody's attachment to an old article of clothing. I mean, I really love this old shirt because I've been wearing this old shirt, but I could go out and buy something exactly like that. But no, I like the old shirt. Is that what we have here, or is there some reason to think that only ByteDance has this?
By the way, everybody's still on YouTube. I'm bringing this whole thing to YouTube right now.
Geniuses at Meta and all of these other social media companies.
We'll cut
they
to
could,
Rumble and do
no
something
matter-
else
they put their
after this
minds
is
to it,
done.
They
But
couldn't come up with this.
like I said, this is going to be a long
I think
day.
empirically, other companies have been trying for a few years to catch up with TikTok and replicate it and have been very unsuccessful. And so that ought to tell you something. And so just imagine the algorithm here as a collection of thousands of editors.
Yeah.
You know,
Yeah, he
imagine
was.
The floors of an
A
office.
lot of them
building
were
being
hate
filled with a
watching, but
collection of
yes.
Editors. You could imagine a situation where that collection of genius that is on a particular floor cannot be replicated by another group of people. And that's kind of what you have here.
All right, I understand that.
Thank you, counsel. Justice Thomas?
I agree.
Anything further, Justice Alito?
Yeah, one other question. I'm intrigued by your Mount Healthy Hunter versus Underwood argument. I mean, maybe you're right, but Mount Healthy arose in an entirely different context where you're trying to get to an employer's motivation. Hunter versus Underwood involved an extreme situation where the court looked at the records of a state constitutional convention and came to the conclusion, apparently, that racism was the only motivation for what was done. But it does seem to me to be potentially quite unworkable and contrary to what we've generally said about legislative intent to apply the Mount Healthy framework to a congressional enactment. Do you recognize, or do you acknowledge that would be very difficult? Because when an act of Congress is passed, there could be more than 250 different motivations for the votes that were cast by the members.
Yeah,
I understand what you're saying now, Joe.
Hunter, the court actually engaged with that problem to some degree. And what Hunter said is, to avoid that problem, we're going to look just at two things. One is the state's brief, which I'd say is the Solicitor General's brief by comparison here, and the text of the law. And here, that's the only thing I need to rely on to get you to the place that they wouldn't have announced.
Well, it gets you to the place that this was part of what motivated Congress. But why does it get you home?
Well,
and particularly when there's a severability clause in this act.
It can't be only part of it. It has to be enough to sustain the entire act, or at least the parts that you wouldn't sever from the act. And so I think the reason why is because it's not just the content recommendation algorithm part that can be theoretically, I guess, severed out. It's also the covered company provisions, and it's just the whole approach of the statute that is based on content, not on data security.
All right, thank you.
So, okay.
Justice Sotomayor?
Save it for the issue.
Yeah, that wasn't a good argument either.
Justice Gorsuch? Justice Kavanaugh? Justice Jackson?
One quick question. You repeatedly say that from your perspective, the government's motivation is that the content might be too anti-American or too pro-China, et cetera. So that's why you think this is a content-based restriction. But I guess I'm curious if you would say the same thing if the government had articulated its rationale as saying, you know, our motivation is to limit foreign interference in American social media platforms or discourse. Isn't that a different motivation from the standpoint of how we characterize this?
I agree, but then the question I would ask if the government said that, which I think kind of in the reply brief, maybe the government does say that, is that how on earth are you then serving a national security interest? You know, if all you're doing is just saying, we don't like a foreign country rearranging cat and dance videos, like it's hard to come in and make a national security argument. So the only way you get to national security, which is the government's own argument, is to look at the substance that's being rearranged and say, we don't like the way the substance is going to be rearranged and curated differently.
Thank you.
Thank you, counsel.
Okay. I see the argument. But it's still a weak ass one, though.
General
God
Pilar.
damn.
Mr. Chief Justice, and may it please the court. The Chinese government's control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing vast quantities of sensitive data about America.
Is this the same? Okay, hold on. I'm gonna play it, but I think this is the same bitch that I had in that other fucking video. About, hold on. Let me see.
And by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data. And as Justice Sotomayor noted, it's not just about the 170 million American users, but also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans. Where we live
okay,
and
it's not
work,
her.
who our friends and coworkers are, what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment, recruitment, and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The Act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats.
What up, Jackie?
Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control. The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security. I welcome the court's questions.
Is there any difference between content manipulation by a non-U.S. company as opposed to a U.S. company? I didn't hear Mr. Fisher make a distinction between the two.
Yes, and I think the important thing to recognize is that the act here is targeting covert content manipulation by a foreign adversary nation. Now, I understand my friends to say—
What difference does that make?
The difference is that there is no protected First Amendment right for a foreign adversary to exploit its control over its speech platform.
What is the difference between
covert and non-covert?
So I think that Congress's concern with the covert operation was that a foreign adversary could effectively weaponize this platform behind the scenes in order to achieve any number of geopolitical goals.
You mean like YouTube and Twitter and Facebook and you mean like that?
Here are some of the examples that come to mind. One of the pages out of the playbook here is for a foreign adversary to simply try to get Americans arguing with one another to create chaos and distraction in order to weaken the United States
Rules
as a
for
general
radicals.
matter and distract from any activities that the foreign adversary might want to conduct on the world
What do you mean by
stage.
covert, though? I mean, is covert just mean it's hard to figure out how the algorithm works? Because we could say that
I
about
gotta
every
be quiet. My wife is on the phone.
No, the covert nature of it comes from the fact that it's not apparent that the PRC is the one behind the scenes pulling the strings here and deciding exactly what content is going to be made to appear on the site. And another way that the
It's just because we don't know that China's behind it. That's what covert means.
Well, I think
it doesn't have anything to do with the difficulty of figuring out what the algorithm is doing. It's just because people don't know that China is pulling the strings. That's what covert means.
What it means means is that Americans are on this platform thinking that they are speaking to one another, and this recommendation engine that is apparently so valuable is organically directing their speech to each other. And what is covert is that the PRC, a foreign adversary nation, is instead exploiting a vulnerability in the system.
Well, if that's
to
all it
suppress and
means, that
silence
like people don't know that China's behind it, like everybody now knows that China is behind it.
No, but it's the specific content that's being manipulated would be unapparent. And so I
But
think
that's true of every search engine. I mean, you can take any of these algorithms,
Yes, ma'am.
whether it's X or whether it's you name it. What are the new ones? Blue Sky. I mean, none of these are apparent, right? You get what you get, and you think that's puzzling, and it's all a little bit of a black box. So you can't just mean it's a black box, it's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly,
What
really,
up,
like everybody
Penguin?
does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening. And therefore, it doesn't guard against the national security harm from the operation itself.
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China. In case anybody were left in doubt after today about that possibility. So you're saying that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is—
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said, 1 of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here. They brought up the example of the Foreign Agents Registration Act, FARA. There you have to disclose the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content? I mean,
Yes, it
every
would.
editor, every newspaper in its editorial room makes decisions about what it's going to run and how it's going to say it. And every algorithm has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how, but they're generally aware. And we think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but we're not arguing about the compelling interest. We're arguing about the tailoring.
Right. And so I guess what I would say, you began by saying the cure for concerning speech is counter speech. Here, I dispute the premise that Congress was specifically concerned about any particular subject or any particular viewpoint.
Okay,
They
she's
wanted to
done.
close off the capability of a foreign government. But in any event, it's very hard to engage in counter speech when you don't know because someone is secretly manipulating the platform behind the scenes. And in particular, what the PRC has the capability to do
Wouldn't the
is
same
simply
thing be
silence
true with
American
a
voices.
newspaper
I mean,
owned
yes.
by a foreign company and a foreign government? You wouldn't know when it's exercising editorial discretion about this article or that article or how it's doing it. So maybe we just need to shut down the Oxford University Press in America, or you pick it, any other foreign-owned Politico, I was told today, is owned by Germany.
So
that would all be okay on your theory, so long as Congress designates that country a foreign adversary?
We are not asking the court to articulate bright line rules to govern all kinds
I
of
understand
hypothetical.
Hold on. That goes back to the Restrict Act too. With that, I think that's what he was trying to call back to. Just because you did, the Congress deems them to be a foreign adversary. Now everything has to change, kind of situation, because something that could be allowed then is not allowed now. want to hear it.
Yeah, but
situations.
I am testing your argument.
Yes, and what I want to acknowledge is that sometimes the court has recognized that a speaker-based preference might reflect a content-based preference. And in the context of ownership of a newspaper, for example, in part because a newspaper is a one-way channel of communication and is generally understood to represent to some extent its publisher's views, maybe the court would more readily infer that a regulation targeting that is actually aiming to target content. But I don't think the court could draw the same
I'm not talking
conclusion
about the
here.
compelling interest or any of that. I'm
Right.
talking about the tailoring. And you're saying we have no alternative but to stop this speech altogether. We can't rely on disclosure. But you say that wouldn't apply to Politico or to the Oxford University Press because?
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise
So, ma'am, you just admitted that our media is 100% biased, no matter what you're looking at. In some way, shape, or form, it is 100. You just admitted it, ma'am. Thank you. Thank you.
distinct interests in this regard, because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does present a distinct national security risk. Of course, the other big difference with the newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
General Prelover, can I, oh, go ahead.
But Tesla isn't a Chinese company. It's not Chinese based. Their headquarters are here in the United States. They do business out of the United States. I mean, didn't he move it to Texas?
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to
If they do, I say they're winning.
Or dissent.
That doesn't mean that it is foreign owned. We've divested every manufacturing out of the United States, but you just want to target Tesla because it has a plant in China. How many other major corporations have the same? Is it because you only want to go after Tesla because it's controlled by Elon Musk, which you were told to hate? Hey, look, the motherfucker scares the hell out of me too. I don't like him for different reasons. You don't like him because you were told to.
That might very well be true, Mr. Chief Justice. And I think the point I'm trying to make is that China is a foreign adversary nation that looks for every opportunity it has to weaken the United States and to try to threaten our national security. And if it has control over this key communications channel, it's hard to predict ex ante exactly how it's going to use that as a tool to harm our interests. But we know it's going to try, first and foremost, by seeking to get the data of these American users, which would be of a piece of all
That's
of the
funny that
activity
you think you
PRC
know
has
as well.
already undertaken to breach our laws.
I can say the same.
OPM, for example, and exfiltrate the background files and security clearances of 20 million government employees, the breach of Equifax to get sensitive financial data, Anthem to get sensitive healthcare data. We know that the PRC has a voracious appetite to get its hands on as much information about Americans as possible.
And I'm going to say this. It's funny that you think you know as well, because did you know we had illegal Chinese biolabs within our borders? How about Chinese police stations within our borders? How about a motherfucker, Lindy Lee? Her father is a goddamn real estate fucking mogul in Pennsylvania. She's being pushed in the front lines of everything. Meanwhile, this motherfucker's buying up area around military bases, allegedly. Don't think that I don't know more.
Possible, and that creates a potent weapon here because the PRC could command that ByteDance comply with any request it gives to obtain that data that's in the hands of the U.S. subsidiary.
Thank you.
General
Suppose,
Prelogar.
suppose that TikTok had no connection whatsoever with any foreign government. It was owned instead by an immensely rich multinational corporation, and Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of
Yep.
the PRC. Would that be the same case?
I think there would be a first order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of protected speech and it would trigger strict scrutiny.
Right.
I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control. And
So your argument depends on the fact that what is at bottom here is the People's Republic of China using TikTok. That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
I'm sorry. I just wanted you to respond to Mr. Fisher's argument.
That's a
about
dangerous
the right
situation,
for
though.
Americans to receive information, say, from the PRC or anyone else, and that even if
I
ByteDance
understand the
did
need
not
for it.
itself have First Amendment rights,
But
that
you're not making a strong
Americans
argument.
would have a First Amendment right to receive that information in the Lamont sense.
Yes, so I think that Lamont reflected a principle that there can be a right of American listeners to receive information. And if Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans, and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do that.
I was trying to think of whether there's a historical analog here, and this is what I came up with, and you can tell me whether it's fallacious. In the mid-20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country. And the Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, oh, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has, do you think that that would have been absolutely fine? And so if the answer is yes,
Who was that woman from
yes,
the
it would have been
show,
fine, it's just like this case, or if the answer is
Enterprise
no,
with Scott Bakula?
why is it not like this case?
So I guess I think I would need to know more information about how the international organization is able to exercise control over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more
Yeah.
about sort of the content. Let's put
Yeah.
the data collection piece of this aside, which seems not very pertinent to my 1950s analog. But very concerned about the kind of speech that the Communist Party was making in the United States, and it turns out that that content was pretty well scripted someplace else.
I think if it was specifically a concern about the content, then that would trigger
Hold on
heightened
a
scrutiny
second.
under the First Amendment. We're not trying to run away from that principle.
Hold on a second. This is what I mean by the Star Trek moment. Where the fuck is the screen again now? What'd I do with it? Oh yeah, it's in another tab. Here we go. That's what I'm talking about. Right here. This one. That's who she is. I forget this character's name, but that was from the show Enterprise. All right, hold up. Let's go back here.
Here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're a little bit, I think you've just given your thing away because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will, that concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress.
I'm trying to listen,
actually
yo.
want to suppress speech on certain topics or certain viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I
Ma'am, you already got shit hardwired into everything that China is sending us anyway. That's called Fault Typhoon. That's been fucking known. That's been warned. That's the only goddamn thing that I will give Christopher Wray credit for. Fuck my life. Why am I doing that?
I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. This law was passed by broad bipartisan majorities in both houses of Congress, and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Yes.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
The court has said it depends. It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. Instead, the court has said it warrants closer consideration. And here, if you look at the US speakers, TikTok US and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
It's hard for me to think of situations, maybe they exist, where our classification based on speaker is not viewpoint or content-based restrictions. I mean, that somebody says, Joe can't talk anymore. We're going to shut Joe up. And we don't know what he's going to say tomorrow or 2 weeks from now. And we don't know what he's going to discuss, but whatever he says is bad because Joe is a bad person. I mean, that's viewpoint and content based, isn't it?
I think when it comes to a foreign adversary, it's not right to view it that way. And the reason for that, again, is this is a sophisticated adversary nation, and we can't just simplistically say, oh, what the PRC is going to want is to see more pro-China content on this app. As Chief Judge Srinivasan observed, there are various ways that the PRC could try to create some kind of false flag operation and actually promote anti-China content, not to dictate how Americans should think about things, but simply to create some trumped-up justification for a military or economic action that the foreign adversary wants to take against us. And I don't think a concern with...
Sorry, ma'am. Didn't we do that with Ukraine? Didn't we do that with Israel? Even though we funded both sides of all that shit? I mean, we caused a whole bunch of shit with Russia. We have a whole bunch of economic trade going on with Russia that funded them to be able to do these kinds of things. All right. I'm tying that back in loosely. I know. But if you're gonna take it that fucking route, even with the Iran Israel conflict thing going on, we funded both sides of that. I'm not gonna sit here and pretend that what you're trying to do is for my best interest at this point in time. When you're making arguments of that nature that make me question everything about what you're trying to argue. Come on now. Jesus Christ, you're literally trying to argue that you should be able to regulate whatever I want to hear simply because the government determines simply because the government decides that that is bad for national security. Like COVID. Everybody remember that talk? Oh, that was national security. No, we got to shut that shit down. And nobody can talk about COVID. Nobody can talk about the vaccines. Y'all remember that? She's saying we need to do this because there could be anti-American propaganda on there that China uses and promotes. Hey, man, you did the same. You did it to us. Yeah, I get the argument. However, you're making a bad one.
Trying to ward off that capability.
Why isn't that viewpoint or content still? We don't know what the content's going to be, but we know it, Joe, is bad.
Because I think the better classification is to recognize that what we're trying to prevent is not the specific subject matter, the specific viewpoint,
Alex Jones,
but the technical capability
Nick
of a
Fuentes.
foreign adversary nation to use a communications channel against this.
I guess I'm just struggling how covert content manipulation isn't content-based restriction.
So
I mean,
again,
the word,
it's because
it's kind of hard to avoid the word content.
I
And
don't
it's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related.
If he was
to
seen with a
content, but I don't
firearm,
think it
everybody
reflects
would know.
Congress seeking to set out in advance.
It wouldn't go
what
through
kind of
TikTok
speech we
first.
should have reflecting certain views on certain topics. Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny. And as the DC Circuit recognized here, we think that this law serves compelling national security concerns that sound in some of the same arguments I'm making here, and that have a longstanding
I get your argument.
correspondence to
I
history
see
and
what you were
tradition
talking
trying
about.
to prevent foreign control.
And then we get to the question whether there's a least less
She is
restrictive
doing a
means. I
horrible
get
ass
that,
job.
whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern, Congress could ban TikTok US from sharing data with anyone and on pains of penalties that would put people in prison and shut the company down in the future, as the government did, for example, with Arthur Anderson.
Not a single.
Why
A
isn't
single
that
leaf.
a less restrictive means available?
So I was surprised to hear petitioner offer that up today because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years.
I see what you're getting at with that, Shane, but back then you also have to understand the internet, what you're seeing right now, wasn't a thing back then. Everybody believed what our TV told us. Everybody believed it. Because back then, they were only showing one side of everything going on in that place anyway, but back then they still had ideological control. They don't anymore. So with this going on, people understand, hey, this is, like Joe said, this is a bigger argument than what everybody really wants to hear it out to be. And he's correct.
Years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the U.S. subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control export restrictions with respect to the the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was
Fair
insufficient
enough.
in protecting our data privacy and
I
security
guess.
concerns.
That didn't come across enough in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor, and you don't have to take my word for it. You can look at the specific terms of the National Security Agreement that ByteDance itself proposed. The relevant definition of the accepted data is at JA 239 to 240, and it references categories of information that would, of necessity, technological necessity and business necessity, have to flow back to China. And the relevant categories are in the sealed appendix, but I would really encourage the court to look this up because it's eye-opening. It is at the Court of Appeals sealed appendix 249 to 252 and 254. If you look at that information, it was a wealth of data about Americans that was going to have to go back to China in order for the
Why'd you leave 253 out? Okay.
platform to just continue its basic operations.
I don't even
and there's
know,
a
but
legitimate commercial justification for that, but it creates this gaping vulnerability in the system because once that data is in China, the PRC can demand that ByteDance turn it over and keep that assistance secret. And the one
Right.
final point on this is that ByteDance was not a
yeah, plus
trusted
the fact
partner
back
here.
then
It
we didn't
wasn't a
have enough to
company
be able
that
to
the
break
United
that
States could
shit the
simply
fuck
accept
down,
to
and nobody
comply
knew
with
what it
any
was because it
requirements in
was
good faith. And there
it was
was
something
actual
nobody ever
factual
read.
evidence to show that even during a period of
And
time
even if you
when the
did,
company was
you
representing
had no way
that
of
it
getting
had
the
walled off
information
the
out.
US data and it was protected, there was a well-publicized incident where ByteDance in China surveilled US journalists using their location data. This is the protected US data in order to try to figure out who was leaking information from the company to those journalists.
General, you want us to look at that, and you get to look at it, but your friends on the other side don't get to look at it. That doesn't seem fair.
That's the sealed appendix, Mr. Chief Justice, so it's their information. They can look at it. It's just under seal to protect their proprietary business information.
General, so I want to go back to the discussion about content discrimination, and we're going to shut Joe up. Here, it seems to me like we are saying to ByteDance, we want to shut you up. And so let's say that I think that that is content discrimination based on speaker. Tell me if I think that, tell me if I have to conclude that it is also speaker-based discrimination and content-based discrimination for TikTok.
No, it is not. And the reason for that is because it would be an anomalous principle to say that an entity outside the United States that can't assert its own First Amendment rights can somehow manufacture that right through the expediency of forming a U.S. subsidiary, especially one that it wholly controls.
So you don't have to stand on that argument
Okay.
that you were having
I
with
agree.
Justice Alito and Justice Gorsuch to still have your point about content discrimination.
That's right. And I think if you're focusing in on the relevant U.S. entities here, TikTok U.S. and the users themselves, this act isn't regulating them in any way. It's not trying to dictate the algorithm that TikTok U.S. can use. And in fact, Congress, I think, was doing everything it could to preserve access to TikTok in the United States in recognition that Americans enjoy expressing themselves and building community on the site.
One last quick question. Sorry, just
No,
one
no,
last
go
quick
ahead, go
question. Justice Gorsuch had asked your friends on the other side whether the new administration on January 20th could extend the deadline.
Or
What's
beepers.
your position on that?
So I think it tees up a statutory interpretation question of whether there can be an extension after the time period for divestiture has lapsed. I would think the court might start with its decision in the Hawley Frontier case, which did recognize the ability to get an extension after a lapse like that.
So it's your position that they could?
We have not run it to ground in part because it's simply not presented here, and I'm not prepared to take a position on that statutory interpretation question. I do want to emphasize, though, that my friends have pointed to January 19th or 9 days from now as a moment when TikTok might go dark. At the outset, of course, Congress was hoping to prompt a divestiture, but I think the more important thing to focus on now is that even if that were to happen, Congress specifically anticipated it and provided authority to lift these restrictions as soon as there's a qualified divestiture. And the reason for that is because foreign adversaries do not willingly give up their control over this mass communications channel in the United States. And I think Congress expected we might see something like a game of chicken. ByteDance.
I just want to ask why the 19th though? Like, that just sounds way too suspicious for some fucked up reason. It's just like, hey, we're gonna do it right before the inauguration. I mean, that just seems way too far out there, even for our government. I'm not gonna lie, it does. It just seems like it's like one of those "Imma take my ball and go home" situation, you know? And is this is that the argument our government is actually putting forward here? Is I just wanna take my ball and go home because 'cause I'm not getting my way? Hold on. I feel like that's actually the situation that's playing it out now that I actually put it in those terms. I feel oh my god.
Saying we can't do it, China will never let us do it. But when push comes to shove and these restrictions take effect, I think it will fundamentally change the landscape with respect to what ByteDance is willing to consider. And it might be just the jolt that Congress expected the company would need to actually move forward with the divestiture process. So
Well,
it's not irrevocable.
That's an interesting point, and I hope Mr. Francisco or Mr. Fisher, whoever's delivering the rebuttal, will address it. So if we were to affirm and TikTok were forced to cease operations on January 19th, you say that there could be divestiture after that point and TikTok could again begin to operate the way, continue to operate.
That's exactly right. There's nothing permanent or irrevocable that happens on January 19th. And I think that Congress might have thought that we get in a situation here where a foreign adversary is doing whatever it can to just not comply. It's hoping the United States is going to blink first through our court system or through the executive branch getting cold feet about enforcing the law. But Congress set a deadline, and I think it thought that deadline would have a forcing function.
Well, let me ask you a question.
Bitch, the argument is January 19th specific. The argument is why is it specific? I don't care if it can be reversed. Everything, well, not almost everything can be fucking reversed. But why? Why is the question?
About your effort to draw a distinction between ByteDance's speech and TikTok's speech. So suppose that the People's Republic of China funds a movie and there is an entity in the United States, a U.S. corporation that thinks, wow, this is a great movie. And while the PRC would not have a First Amendment right to show it in the United States.
Give me a second. Tweak just sent this into the Discord. It's relatable. It's been a rough year. It's the first week of January. Yeah. Yeah, it is. It's been rough as fuck, dude.
Would you say that the American company would not have a First Amendment right to do that? Because whatever expression there is in that movie, it's the PRC's expression. It's not their expression.
No, I wouldn't make that argument. And I want to be really
thought that was
careful.
the argument that was being made, no?
Fair
No.
enough,
So our
but
argument is that this is not a direct
just
regulation
dumb.
of protected speech in the first place.
It's like I
or at
want to
most
pack
it was
my.
more an
I'm just
intermediate
gonna pick up my
scrutiny
ball and
because of
go
the
home
indirect
right
effects
before
that it
you
might
start
have on the
winning.
American users or on the U.S. subsidiary. We're not suggesting that if Congress sought to directly regulate and prohibit speech in the United States based on concerns about its content or viewpoint, that's somehow immune from First Amendment scrutiny just because it comes from a foreign source. Obviously, that kind of law is going to trigger strict scrutiny. And I imagine it would be a different constitutional analysis because it's hard to imagine the same profound national security harms that would exist in that scenario as compared to what we have here.
Thank you.
General, isn't the whole point of the divestiture requirement that the content on TikTok would be different if it was owned by a different company? I'm still struggling with your insistence that this is content neutral versus content based when we have that kind of circumstance.
The reason that I am continuing to try to hold the line on that is because there is nothing in the act that would directly dictate any different mix of content on TikTok. The US subsidiary could use the same algorithm, show the same content by the same users in exactly the same order. It's not about trying to interfere with the US subsidiary's exercise of editorial judgment in any relevant sense. Instead, all Congress was doing was homing in on the problems of having a foreign adversary be able to interject itself and be able to harvest
But
the
your
data.
friends on the
or
other side
exercise-
say that the motivation for doing that is because the foreign adversary might influence or change the content. So content is, I mean, content matters, doesn't it?
I think that content was relevant to Congress's concern about an adversary having control over the communications channel. I think not again because
You're
of
not
any
wrong,
particular
Shay.
concern about viewpoints or subjects, but just
isn't
that
that
this would be a
relevance? Isn't that relevance enough to trigger at least some scrutiny, with a heightened scrutiny from the standpoint of our legal tests?
I certainly understand that intuition, and if the court thought that it were prudent to simply try to rule narrowly here and not dictate broader First Amendment principles, we have no problem with the court assuming that heightened scrutiny applies. We think the law easily satisfies it. We do think that intermediate scrutiny is a more appropriate framework for this kind of law that's not directly targeting protected speech. But in any event, there's a compelling national security interest here, and the law isn't just narrowly tailored, it's precisely tailored. It's trying to fix the thing that's creating the problem, which is the PRC's involvement and the Chinese government's ability to exercise this control over the corporate entities.
How are we supposed to think about the two different rationales here and how they interact? The data collection rationale, which seems to me at least very strong, the covert content manipulation rationale, as the hypotheticals have illustrated, raise much more challenging questions for you about how far that goes. And if that alone, you didn't have the data collection piece, you only had the covert content manipulation piece. And then Mr. Fisher's point, Mr. Francisco's, that Congress would not have enacted this just based on the data collection rationale alone. Just your understanding of how the two arguments fit together.
Sure, and let me walk through our defense of the data protection rationale and why we think
I gotta show this. Just a quick little search. Toilet stolen. 4 charges theft of 18-karat gold toilet. Now this one I can understand, all right? 4 men have been charged in the theft of a solid gold toilet, which was valued at roughly $1.25 million when it was stolen. The Crown Prosecution Service said Monday. Officials list the current value of the toilet, which has not been found, at 4.8 million pounds, or roughly $5.93 million. I get you. Okay. Toilet was taken from Blenheim Palace, Winston Churchill's birthplace, in 2019, just days after its installation. I get why this one was stolen. It's just funny as hell the way this, I just like toilet stolen. This is the first thing that came up. That's going to be an interesting read. Hold on. While this goes on, I've got to read it.
it's a full justification for this law, and the court could stop there and then be responsive to their arguments that somehow the interest in preventing covert manipulation somehow taints it. So just on data protection, I think that it should be beyond dispute that, of course, our nation has an enormous interest in keeping the sensitive data out of the hands of our foreign adversary. And it should also be beyond dispute that our foreign adversary has an existing capability through its laws and through the way that these companies are integrated to get its hands on that data. There is no question that Congress was sincerely motivated by that concern. There's a whole lead up to the statute here where the executive branch across 2 different presidential administrations was expressing concerns about the data problems. Congress was extensively briefed on those problems. It passed a companion data protection statute at the same time that was intended to prevent selling data to foreign adversary nations. The statute is shot through with protections that I think are key to this concern about closing off the vulnerability of
This
access to
story
the
is
data.
funny as
So
fuck.
that's a sincere justification for Congress's desire here to act. We think it's a compelling interest and it's narrowly tailored. Then you get to the question of what to do about the fact that there's also this interest in covert content manipulation. And in the First Amendment context,
I
this
think we
court
should
in
bring this
cases
to
like
Meme
Heffernan
Kingdom.
has made clear that once you have a justification that satisfies the First Amendment, you don't need to go further and look at other justifications to decide whether they would independently satisfy First Amendment
Where is
scrutiny.
it?
So I think it's not necessary for the court to go on and probe whether it thinks that covert content manipulation itself independently justifies the law. Now, my friends say that's all fine and good, but they think covert content manipulation is just per se illegitimate. And I honestly don't understand how that argument could carry the day, because just imagine if Congress passed a law that said the PRC can't covertly manipulate TikTok. Obviously, that law is not going to violate any constitutional
Oh,
principle.
hell yeah.
It's a
Well, no, they were
laudable role, I
caught with
think,
it, but
for
yeah, the
our
toilet's
legislature to
gone.
protect us from foreign adversary interference like that. And so there's nothing that's inherently impermissible about wanting to guard against that risk. Maybe you could say that it sweeps in too much protected speech in the way it's operationalized
The
in the
shit
act
you
here,
find when you
but
just
there's
put
certainly no
random words
fundamental
into Google.
taint or anything akin to racial discrimination to call into question whether Congress could seek to vindicate that as one of many interests. So I guess to just kind of bring it all together, what I would say to the court is they have basically acknowledged that data protection is a compelling interest. That was Congress's real interest. It provides a sufficient basis on its own to uphold this law. The court could say just that and affirm.
I don't know how we do that unless we accept your argument that the post-divestiture provision that stops them from conferring on the algorithm is not a speech impediment, meaning it's very hard for me to say that it's not motivate to decide that question, that it is a speech impediment, and one that on its face itself has to be analyzed separately from the data.
So, Justice Sotomayor, let me begin by saying again that we do think that an interest in preventing any operational agreement between the U.S. subsidiary and ByteDance, which is the relevant provision you're talking about, is justified by data protection alone. And that includes with respect to cooperation on a content recommendation algorithm, specifically because of the concern that it necessitates data flows between the companies. So I think that as a factual matter, that could justify Congress enacting. But to the extent that you think that actually the prohibition on coordinating with respect to an algorithm reflects some kind of impermissible content-based problem with the statute has a severability clause, and I certainly don't think that it would give the court a basis to invalidate this law or to stop it from operating with respect to all of the provisions that operate to protect data security. At most, it would suggest that that little piece of the law has to be on its own severed from the rest of how the statute operates.
How does that affect whether we would apply, because assuming it's data protection, then I would think that strict scrutiny wouldn't necessarily apply. I could understand applying intermediate scrutiny. But how do we do that with respect to this part, the algorithm issue? How do we get to intermediate scrutiny with respect to that?
The way you get to intermediate scrutiny there is to recognize that prohibiting foreign adversary control over the operations of the platform, including with respect to the fundamental backbone of the system, is not based on any protected speech or content based in the relevant sense. I've been thinking of it as akin to something like a piece of software you might have on your phone that would allow the Chinese government to listen in on every American conversation. If Congress wanted to enact a law that patched up that vulnerability and said, you can't use that piece of software or you can't coordinate with Chinese companies with respect to it, clearly we would recognize that closing off that capability of China is a laudable and, in fact, compelling government interest. And I think when it comes to the risks,
I don't think there's another player in any of that game.
Here, it's similar in kind. It's simply trying to prevent access by the Chinese government to the TikTok system writ large, and that includes through the use of the algorithm.
Thank you.
Could the president say that we're not going to enforce this law
I think as a general matter, of course, the president has enforcement discretion.
And would that then adequately would that be binding? In other words, protect the regulated community such that they could rely on that under due process principles going forward?
That raises a tricky question. So I think there would be
Then
a
it's not going to
strong.
be adequate.
Well,
Right?
I think there is a strong due process argument that the third-party service providers could invoke if there were enforcement action based on a period of time when the president said the law wouldn't be enforced. The kind of
They're not going
canonical
to take
case.
that risk unless they have the assurance that a presidential statement of non-enforcement is, in fact, something that can be fully relied on, because the risk is too severe otherwise, right?
I think that they might judge that based on this court's precedent in the due process
think I'm getting
space
sick.
and principles of entrapment
Give
by
me a second.
estoppel, maybe they have a sufficient safeguard here to allow them to continue to operate. I would think even before a non-enforcement policy were announced, of course, the president-elect would want to review all of the updated national security information that has come in over the last 4 years that undergird Congress's judgment here. But the final thing I would say is that even if you think the third-party providers are simply going to choose not to continue to provide these services because it's too much of a risk to take on, again, that's not anything permanent or irrevocable, and that might be just what the PRC and ByteDance need to start taking seriously some of the public reporting about interest in acquiring the company.
At one point, Mr. Francisco suggested that what we might want to do and what he would regard as certainly preferable to a decision affirming on the merits is to issue an injunction pending, I guess, consideration of what we now regard as the cert petition that was filed here. What do you think of that suggestion?
So I think this court doesn't have any basis to enter a temporary injunction unless it thinks petitioners are likely to succeed on the merits of the First Amendment claim. And to be honest, I think that there is no argument to be made that you should find that likely success. This is an act of Congress. This isn't some unilateral action by the executive branch, but it actually was action in parallel between the executive and Congress, where Congress took action to close up a loophole in some of our laws. The executive had tried to force divestiture of TikTok under the Trump administration, but that had gotten tied up in litigation about those authorities. So Congress came in and provided additional authority based on a substantial record, including with respect to the data harm. And I don't see any basis for this court to displace the deadline that Congress set without finding that actually there is a potential First Amendment problem here.
Do you think we have the authority to issue an administrative stay as we have done in other cases, or do you think that the January 20 deadline prohibits us from doing that?
I don't think this court has
Yeah,
a
coughing and
formal
sneezing a
basis to
lot.
not issue an
I just
administrative
hacked
stay
up
if
a
it believes
fucking
that was
lung
necessary
and
to
sneezed
assist in
my
the court's own consideration of
face
the
off.
case.
But
And I
yeah,
would obviously
I'm
defer
getting
to the
sick.
court and whether it has a sufficient time to resolve the case. But we are here ready to submit the case today, and I think it is in the interest of Congress's work and our national security to resolve the case and allow the statute to take effect.
Can I just test to see whether your recollection of what Mr. Francisco said?
I mean, it just
about
does
a
seem like
warning
she just
is,
wants to say the government should have control just
consistent with
because it's the
mine. I
government.
did not hear him say, he can address this in rebuttal, that it would be acceptable to his client if Congress had said there has to be a stark warning on every TikTok, such as warning, the communist China is using TikTok to manipulate your thinking and to gather potential blackmail material. Did you hear him say that that would be okay?
I don't think he's made that concession, but even if he had, I don't think that would address the government's national security concerns. And one of the points here is that it's not just data privacy. So even if you could somehow put users on notice that the PRC could obtain their data and they choose to disregard that, it's not a data privacy interest, it's a national security interest. There's a distinct sovereign harm to the United States if our foreign adversary can collect this massive data set about 170 million Americans. And as Justice Kavanaugh touched on, there are a lot of teenagers using TikTok today someday who might ignore a warning like that and not really care, but they're going to grow up and they might become members of our military. They might become senior government officials. And for the Chinese government to have this vast trove of incredibly sensitive data about them, I think obviously exposes our nation as a whole to a risk of espionage and blackmail.
Thank you.
I did want to touch briefly on the questions about history and tradition here, because my friends have said several times that the Communications Act of 1934, which we think is roughly analogous to the type of restriction that Congress was seeking to enact here, is justified entirely by concerns about scarcity, how you can't have sufficient bandwidth.
I mean, maybe they
And
don't
I, of
get your
course,
address.
recognize that scarcity is what created the need for a licensing regime in the first place. But I think it's important to clarify the historical record here that in choosing to limit foreign control of radio stations, of broadcast stations, Congress specifically cited a concern about national security. That is written into the statute. National defense was one of the listed purposes of having that kind of restriction. And so I don't think my friends can succeed in being dismissive of that concern about history and tradition and what it shows about the national security judgments that undergird this law. The one other factual point I wanted to make, to be responsive to a few points that my friends have touched on, relates to whether TikTok US has the ability to alter this algorithm, whether divestiture is feasible, how ByteDance has manipulated the platform in the past. With respect to the algorithm, I think we're simply talking past each other. We don't dispute that TikTok US might engage in some functions in the United States to customize the algorithm for a US audience. The thing we're worried about is happening long before that, over in China, where ByteDance is developing the source code, creating the basic backbone and functioning of the system, and is then blasting out the algorithm for use by the various subsidiaries in their home country. So we're not seeking to regulate any activity that TikTok US is engaged in here. Instead, what Congress is doing is trying to close off the vulnerability of PRC access abroad. With respect to the feasibility of divestiture, my friends have said it would have been impossible to do this within 270
Andrea?
days. You know, at the outset, obviously, there's no inherent impediment to divesting a social media company. We just saw Elon Musk buy X or Twitter in about 6 months from offer to completion. And even with respect to this particular company, I think my friends are not well positioned to complain about the timeline, because they've been on notice since 2020 that unless they could satisfy the federal government's national security concerns, divestiture might be required. But in any event, I don't think that the court should fault Congress for trying to balance competing interests here in making sure that there was a period for compliance and trying to preserve access to the platform
Their
for
payment
Americans
system for YouTube.
while taking steps to safeguard against the risk to national security. Finally, with respect to the question of whether ByteDance has taken action on the PRC's demands, there is evidence in the record that Congress consulted to demonstrate that outside of China, ByteDance has taken action to misappropriate data at the PRC's request. That included efforts to track dissidents in Hong Kong, protesters there, to track Uyghurs in China itself. We know that ByteDance has misappropriated U.S. data with respect to surveilling of U.S. journalists, and there was evidence in the record reinforcing the conclusion that ByteDance has been asked by the PRC to undertake efforts to censor content and manipulate the platform at the behest of the Chinese government. So I don't think there is a factual basis to dispute the record that Congress had before it. If the court has no further questions.
Yeah, Joe's right. This is a horrible ass argument.
If I understood correctly, under President-elect's first term, he passed an executive order requiring divestiture, correct?
That's right.
And this, that was challenged in court and state as a result of him exceeding his executive power to do that. But this bill followed a bipartisan investigation, correct?
Yes, that's right.
I am a little concerned that a suggestion that a president-elect or anyone else should not enforce the law when a law is in effect and has prohibited a certain action, that a company would choose to ignore enforcement on any assurance other than the change in that law. But putting that aside, on the 19th, if it doesn't shut down, there is a violation of law, correct?
Yes.
And whatever the new president does doesn't change that reality for these companies.
That's right.
How long is the statute of limitations in effect? Assuming that they violated it that day and later continue to violate it. But how long does the statute of limitations exist for a civil violation of this sort?
It would be a 5-year statute of limitations.
Thank you.
Thank you, counsel. A rebuttal?
Thank you, Mr. Chief Justice, for points, all of which go to why we think this law would fail, whether you applied intermediate scrutiny or strict scrutiny. I'd like to begin with the least restrictive alternative, simply prohibiting TikTok Incorporated from disseminating any of the sensitive user data to anyone, including ByteDance, under the threat of massive penalties. That is definitely a less restrictive alternative. Now, my friend pointed to the NSA negotiations. Well, the sensitive user data that we're talking about and that were of concern in the NSA negotiations were not the type of technical data that she's talking about. The NSA did allow certain types of non-sensitive technical data to go back and forth, but that wasn't anybody's concern. And as we say in page 23 of our briefs, they simply cut off the negotiations without ever raising those concerns. But to be clear, if that's a concern, sweep that into the ban too. Put in that non-sensitive technical data into the ban too. We'll deal with that. It's a lot better than simply being forced to shut down. So that is most definitely a less restrictive alternative that would address data security. We talked about the under-inclusiveness, and Temu and Shein, the two large e-commerce sites. Justice Kagan, you might have seen Temu during the Super Bowl. It was heavily advertised. It's one of the most popular e-commerce applications in the United States. It's got 70 million users. Justice Sotomayor, you were asking what they collect. This is from Joint Appendix 339 to 343, the U.S.-China Economic and Security Commission Review Report. Shein relies on tracking and analyzing user data, draws on customer data and search history with the assistance of artificial intelligence algorithms. It requests users share their data and activity from other apps, including social media. So they apparently go into your social media apps and suck up all of the information. Because they're e-commerce apps, they take names, addresses, and credit card information. If you look at the privacy policies on their website, they collect location data. It looks like they might even collect, at some level, GPS location data. So they collect massive amounts of data. Point 3, their mere covertness argument makes no sense for the reasons that the court explored. If mere covertness were the issue, a disclosure would make perfect sense. Yet they're not concerned about mere covertness. They're concerned, as my friend suggested, with getting Americans to argue with each other. Well, you know, as far as I can tell, that's what news organizations do in this country every single day. That's what we call editorial content. That's what we call content itself. And so it's trained directly on the content. But even if you thought somehow that the mere covertness were the issue, that definitely could be addressed through a risk disclosure. So the data sharing ban,
of course, man,
risk disclosure,
that's the way it always
works.
works.
Less restrictive alternatives, and had the government considered.
Hey, Spuds, you want to know some fucked up shit? If you don't have an LLC doing what I do here, any kind of money that I make, government gets 40% off royalties.
Them and rejected them, we would be in a different position. But if you look at this record, those are two less restrictive alternatives that the government did not address at all. Whether you apply strict scrutiny or intermediate scrutiny, that is fatal, because under both standards, restricting speech has to be the last resort, not the first one. And when you fail to consider less restrictive alternatives, you fail under either standard. My final substantive point is we absolutely think this court has the authority to enter an administrative stay. I didn't understand my friend to disagree with that. We think that given the enormity of this decision, given the complexity of this case.
Yeah, after this, we're going to cut to Rumble, and I'm going to listen to that.
Administrative stay. I also think you could enter a preliminary injunction. Yes, likelihood of success is one standard, but you don't have to determine ultimate success. And as you do in other related contexts, like with respect to stays, you often make clear that you are not addressing the merits of the case. I think you could do that here. The bottom line, Your Honor, is this case ultimately boils down to speech. What we're talking about is ideas. And my friends on the other side, when you cut through everything else, are ultimately worried that the ideas that appear on the TikTok platform could in the future somehow manipulate Americans, could somehow persuade them, could somehow get them to think something that they ought.
We have proof of it.
Well, that whole notion is at war with the First Amendment. If the First Amendment.
You have a point, but when the whole notion of banning anything that is in opposition to that, well, that goes against the First Amendment. You shit fuck.
Means anything, it means that the government cannot restrict speech in order to protect us from speech. That's precisely what this law does from beginning to end, whether you look at its text, whether you look at the government's justifications in its brief, where they talk about being worried about speech criticizing our leaders or undermining democracy. It's what you see in the House report, which trains specifically on the dangers of misinformation, disinformation, and propaganda. And it's what you see in this legislative record writ large, which is saturated with objections to TikTok's existing content. We ask that you reverse the court below. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
All right. So, before the YouTube side, I got the screens backwards here. I had to remember that. There is your Rumble link. We're going to hear this Joe Rogan, Mark Zuckerberg situation that just dropped not too long ago. We're going to go to Rumble for that. I don't want to get hit by YouTube because YouTube's a bitch commie. But yeah, we're going to go ahead and hit that up. But ladies and gentlemen, appreciate the fuck out of everybody for this YouTube segment. I do appreciate Joe coming on here and bringing a new view to it, because Joe made a really, really, really good point. Now, I see his fucking argument about it all, and I agree with him. But ladies and gentlemen, you got the link. We're about to go over to Rumble. You got 3 minutes.
You're never gonna make it, you're not good enough. There's a million other people with the same stuff. You really think you're different? Man, you must be kidding. Think you're gonna hit it, but you just don't get it. It's impossible, it's not probable, you're irresponsible. Too many obstacles, you gotta stop it, yo. You gotta take it slow, you can't be a pro. Don't waste your time no more. Who the fuck are you to tell me what to do? I don't give a damn if you say you disapprove. I'm gonna make my move, I'm gonna make it soon. And I'll do it cause it's what I wanna fucking do. Cause all these opinions and all these positions, they come in millions. They blocking your vision, but no, you can't listen. That shit is all fiction, cause you hold the power as long as you're dreaming.
There's no way that you make it, and maybe you could fake it, but you're never gonna make it. Aren't you just gonna take that? Make them take it all back. Don't tell me you believe that. Aren't you just gonna take that? Or will you fucking fight back? Fight back.